Good afternoon, everybody. Um, we'll start the session today. Today we have the workshop on the topic IBC vis-a-vis PMLA. And just a couple of announcements before we start the session. Firstly, I would request everyone to not post their registration numbers in the chat box because we will note your attendance through the Zoom login and the invoices that you've made, and we'll share a CPE mailer as well. So there is no requirement of sharing your registration IDs, registration numbers in the chat box. Secondly, I would request everyone to please keep their cameras on and keep this session interactive, discussion based, so that everybody can learn from the session. And Harmeet ma'am has very genuinely agreed with us to have this session and make it discussion based so that everybody learns from it. So we'll start the session today. I would request everyone to be interactive and participative in the session. I'll start the session off by introducing ma'am, just a brief introduction for ma'am. So Harmeet ma'am is an insolvency professional, lawyer, and a practicing company secretary. She is currently a designated partner with RRR Insolvency Service Experts LLP, which is an insolvency professional entity. She has more than 15 years of industry experience in the secretarial and legal areas. She's also a certified trainer and has been impaneled as a faculty with ICSI. She is committed towards the empowerment of women and to propagate the idea of gender equality. Academically, in addition to being an IP, she's a commerce graduate from SRCC. She's also done LLB and has a postgraduate diploma in business administration and computer application. Ma'am, welcome to the session, and thank you for agreeing to take up this session, and we can start the session.
Thank you so much for the introduction, Ankita. And thank you everyone for joining on time. And I am still seeing that we are 34 people and I'm expecting 10 to 15 more people in.
Ma'am, around 20 more people will
join eventually. Yeah. All right. So after lunch relaxation to the IPs. Otherwise, IPs are not spared. Get such relaxations at any forum. All right, no problem. We can just start with a discussion. And I would request the participants to switch on their cameras so that I also interact with people and not with the screen. You must have heard the same lines from all the speakers because while speaking to the screen, you just think that you are just practicing your session, you are just practicing what to say. So it is always nice to look at the people live, right? It is always two-way communication thereafter. So shall I just start the presentation or we wait?
Ma'am, we can start.
All right. So I'm sure we are all aware of the subject for today's discussion, that is IBC vis-a-vis PMLA. And all of us are aware that the subject is still not decided, and the fate of the decision IBC or PMLA supremacy is in the hands of government as well as Supreme Court. So let us go through what we already have seen through the years on this subject, and I'll also take views from the participants who have any important sharing for the other participants so that we can learn from your experiences and views. And during the presentation, whatever is being shared here is mostly derived from the judgments given by various courts and tribunals, and some of the personal views of the speaker, but I am sure you are aware that the firm or the partners are not liable or responsible for any action if taken by any participants after following any of the advices given under this presentation. So please don't consider the presentation or its contents as a professional advice. We are just sharing our views on the subject. All right, so let me just adjust my screen because I can't see my presentation. Is it available to, can you just see?
Ma'am, we can see the presentation.
I can't. let me adjust my screen, and I invite any of you, if you have any experience in the subject or maybe on the concept, if you just wish to start. Yes, this is better. If anyone would like to tell the forum about the both the laws, IBC as well as PMLA, or I just start telling about the theory what I have derived from various sources. All right, let me start. So what do you mean? What do we mean by insolvency? It has not been defined under the IBC. We are well aware of that fact. So let us see what Justice N.V. Ramana had to say at an informal forum. He said, I must quote Lord Mixon, who said that insolvency is not a very thrilling or amusing subject. However, as Edward Jenks, the noted English jurist, said, uninteresting as it may be, it is nevertheless a very important subject area. And why it is so important? To that, Justice Ramana had to say that the importance of this subject cannot be undermined, as it has implications on a host of other sectors such as employment, banking, company law, etc. And over the past 6 years, we all have seen the law graduating itself from being a new law to a evolving law, and now a well-established law, I think, and the economy at large. Therefore, the progress of insolvency law must happen in consonance with its philosophy. And most of us are aware about the insolvency law. So I am not going to tell much about the IBC today, but important is the other aspect, which I think all of us should understand by now, considering what is affecting our economy as a macro subject, that is PMLA, and what is there in it to affect us at the micro level as well. Again, we are aware that prime objective of IBC is bestowing a fresh lease of life to the corporates and individuals. We know it, but we sometimes tend to forget it, because बार-बार बोलना पड़ता है, the tribunals, the judges, the academicians, they always try and harp upon the fact that IBC is aimed at revival and resolution and not at the recovery. So we also, while dealing with the CD or the corporate person or whosoever, PG, we also need to keep this in mind, that the ultimate objective of the government or the legislature or the ecosystem from us, the goal is to revive and not to liquidate, not to just sell and fetch money out of it for distribution. Out of this process, either the business gets a new promoter, or the unviable businesses are closed, or the unviable project is closed, or maybe a group-wise insolvency, the project-wise insolvency. We can just take one project into other direction and the other viable project can continue. So the potential value in the assets can be unlocked, and the business, the assets, the company, all the entities are separately placed in the list of stakeholders. So we can just cater to the needs of all of them. The key economic question in the bankruptcy process is envisaging the best resource when the default occurs. One possibility is to take the firm into liquidation, and another is to negotiate a debt restructuring, where the creditors accept a reduction of debt and expect that the negotiated value exceeds the closing value. Another option is to sell the firm as a going concern and use a takeaway to pay the creditors. In any case, creditors have to be paid. So one must not think that the ultimate objective is recovery. It is a byproduct that all dues are paid, right? Preamble, an act to consolidate and amend the laws. Here, I would like to draw your attention to the point number 3, that is the maximization of value of assets, and point number 5, to balance the interest of all the stakeholders, including alteration in the order of priority of payment of government dues, right? So I'm sure most of us are aware why this point number 5 was introduced in the preamble. If anyone would like to throw some light on this. No, let me tell you. The government wanted that at least the government authorities, for example, income tax, for example, PF or other dues, which are recoverable from a company and which are ultimately a burden on its business. So government is the only stakeholder where it was thought that they can forego their right of recovery and they can forego some amount of at least the penalty or the fines etc. can be foregone in the process of revival of a company. Therefore, it was well identified goal of IBC that the priority of payment of the government dues shall be altered and they will be brought down.
Yeah, and it has been taken from the reference also from BIPA, wherein the government authorities were in the first queue to take their money.
Yes.
So
Yes.
that's why
And the dues were huge.
yes.
It was an unnecessary burden on the business of the company, right? Interest on tax payable. What is that? That is a penalty which should not come in the way of revival of a business, right? So what is laundering and what comes to our mind when we think about this word money laundering, PMLA, ED? We immediately think about buying assets, right? While we come across the news, etc., we see properties being bought out of illegal money. So that is the exact interpretation of money laundering. So why and how it becomes a crime and what is there in PMLA, we'll just go through that today. So where did the word come from? It started in 1973. The first time the word was used, suitcases stuffed with $2 lakh of Republican campaign funds, money being laundered in Mexico. That was the first time this word was being used as such. Otherwise, the Black Laws Dictionary defines the word as act of transferring illegally obtained money through legitimate people or accounts so that its original source cannot be traced. So what does the act say? What is the preamble? PMLA is an act to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and for the matters connected therewith or incidental thereto. So there are two objectives. One is to prevent and one is to provide for confiscation. Where does it come from? The preamble itself says, tells us the importance, why and how this act was promulgated. The General Assembly of United Nations, since we are a member over there, and it calls upon the member states to adopt national money laundering legislations in their respective countries, draw structured programs for that, and make laws on that. So that is why and that is how Money Laundering Act was introduced. The idea started in 1998 and the law was implemented. Law was passed in 2002 and it was implemented with effect from year 2005. PMLA empowers certain officers of the ED to carry out investigations in cases involving offense of money laundering and also to attach the property involved in money laundering. PMLA envisages setting up of an AA to exercise jurisdiction, power and authority conferred by it essentially to confirm the attachment. Now there are 3-4 terms I have been using and I will be explaining those terms to you because it is very important for us to understand the meaning of those terms, and until that we won't be able to maybe do justice to our CD who is currently undergoing any such issue. So one is the offense of money laundering, other is the attachment, one is the provisional attachment, other is the confirmation of attachment. It also envisages setting up of an appellate tribunal to hear appeals against the order of AA and the authorities like Director FIU IMD. PMLA envisages designation of one or more courts of sessions as special court or the special courts to try the offences punishable under PMLA and offences with which the accused may, under the Code of Civil Procedures, be charged at the same trial. It also allows the central government to enter into an agreement with government of any country outside India. Now that is very important for enforcing the provisions of PMLA, exchange of information for the prevention of any such offense and under the corresponding law in force in that country or investigation of cases relating to any offense under PMLA. So these are, this was just a summary of what all is there under the Act and what it aims at. So one very important term is CFT. This is where the Act has taken birth from. CFT and AML are the terms which have been used by the UN for all the member countries, and there was a Vienna Convention where it was imposed on all, where it was directed to all the member states to make such laws against anti-money laundering and countering the finance of terrorism. Why the terrorism and financing are related? I'm sure we are all aware, because terrorism also needs money, and the money is flown in such a manner so that it looks legitimate. So this is the history of PMLA, International Standards on Combating Money Laundering and Financing of. This is the Financial Action Task Force, which is called FATF. And every 2-3 years, the rules, the structure is changed. New methods of implementation are made under FATF, and it is a very important law for the economy for any nation.
Madam, who all countries like India is having this trade pact or agreement with as of now?
I think all the member states of the General Assembly would be having that, but I'll need to confirm that back. Because
you know
agreements on cooperation, providing information, and carrying on investigation in that country. So those agreements and of cooperation are there with all the member states.
Okay, so of course UK is not in the list, I guess.
I'll need to check that.
Okay.
Okay. Developing countries are more vulnerable. We might be thinking that how and why India is subject to so many such crimes, and why not we have been able to put a brake on the speed. The rate of growth of such crimes is beyond our reach, because here we are vulnerable to money laundering because the developed countries already have the systems established since they are already the financial center countries, and they already have those regimes for anti-money laundering. They have laws, they have systems, they have guidelines. In 2003, we first thing the banks and financial institutions introduced the KYC, if you remember. So prior to that, the KYC was there in many countries for 20-25 years till that time. So why we are not there in the race? Because we were developing and we were not aware till such time in 1998 in the Vienna Convention. It was the advice to us to follow those systems, to follow those guidelines. Thereafter, many changes were made, and after these three people, the Fugitive Offenders Act, etc., were made in 2018. So every time there is a need created by circumstances, new laws are implemented. And PMLA was implemented in 2005 after much. That history I've not covered in this. We don't need to. So the gaps in national anti-money laundering system are exploited by the launderers, who tend to move their networks to those weak countries which have ineffective countermeasures. With the damaged integrity of an individual financial institution, there is damping effect on the FDI, and you can understand the similar impact on a country's commercial and financial sector in case the image of that country is damaged in the international economy. We can think of a situation where inflow of foreign currencies is in a way good for our economy, for any economy. In times of slow growth, an infusion of hard currency can boost a country's foreign reserves. It can ease out the hardships associated with the budget contracting policies. But while these are the short-term benefits, the long-term effects of money laundering and the inflow of foreign currency is always negative. One difference between official borrowing and laundered funds is that the former can be controlled by the government, whereas the funds owned by criminals generally escape the government's ability to control and regulate the economy. How do they escape? That we will understand. So these are all the impacts of money laundering. I hope the social, economical and political impacts we are aware. Important is to understand the process of money laundering. Just look at this chart. The first step involves the introducing cash into the financial system by some means. That is called the placement of money in the target financial system. Second step is carrying out complex financial transactions to camouflage the illegal source. That is called layering. It involves the transaction, multiple transactions are made so that the origin is lost in between, so that you cannot just track where the money came from and to and how many hands it has changed and to where it has reached. So by the time there are multiple layers covered under that financial transaction system, the ultimate layer, the ultimate place where the money has reached would look like legitimate and mostly legal. So that is called layering. Third important step, third final step, that entails acquiring wealth generated from transactions. So such money, when it has reached to that 10th or 12th destination where it was destined to, from there the ultimate transaction is made. For example, giving donation to some maybe NGO which is actually involved in some other activities which are not legal, or maybe buying properties for whose beneficiary is someone else. So those transactions are carried out in the hands of the nth number of layer, so that the ultimate property purchase is generally not directly linked to the original money infused in the market. So ultimate objective is integration. There are many different ways in which the laundered money can be integrated back with the criminal, and then that property bought with that, for example, artwork, jewelry, or high-end automobiles, they are common ways for the launderer to enjoy their illegal profits, and that is integrated back into the actual beneficiary, who is the criminal. Impact of money laundering on development, I'm just skipping this. Initiatives taken at international level to deal with the problem of money laundering. Transactional cooperation is of critical importance in the fight against this menace. The UN or the Bank of International Settlements took some initiatives in 1980s to address the problem of money laundering with the creation of FATF in 89. Regional groupings such as EU, Council of Europe, and Organization of American States also established AML standards for their member countries. The major international agreements addressing AML include the UN Convention Against Illicit Trafficking Drugs and Psychotropic Substances, that is a Vienna Convention, and Council of Europe Convention on Laundering, Search, Seizure and Confiscation of Proceeds of Crimes. So we are deriving our act from this convention. The role of financial institutions and banks in preventing and detecting the money laundering has also been the subject of pronouncements by the Basel Committee on Banking Regulations, Supervisory Practices, the EU, and the International Organization of Security Commissions. So you can understand how many and at what level the subject is being dealt with. Economic crimes in globalizing society, I'm just skipping this as well because this is just the background where and why PMLA anti-money laundering acts are important. Let's come back to the objectives of the act. Primarily to prevent and control the money laundering activities, to confiscate and seize the property which is derived from or involved in money laundering, to provide punishment for offense of money laundering, to appoint the AA and appellate tribunal to deal the matter connected with money laundering, to put obligation on banking companies, financial institutions and intermediaries to maintain records, and to deal with any other issue connected with money laundering in India. Now, exactly what is written in our laws. Offense of money laundering is an important definition. Section 3 provides that definition and says, whosoever, directly or indirectly, attempts to indulge or knowingly assists or knowingly is a party or is actively involved in what? So these 5 points have such a wide coverage that no one is spared under this definition. In any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use. Plus, now this and is very important. What will make any money laundering an offense under this act? If those activities of concealment, possession or acquisition of proceeds of crime are being projected as untainted property. Untainted is the legal, legitimate asset or property. So whosoever is doing this activity and trying to conceal that or possess that or acquire that or enjoy the ownership of that property, and along with that projecting it to be a legal property, legal money, he shall be guilty of offense of money laundering. So he is connoting any person is having the same general definition, including all the entities in the eyes of law. For removal of doubts, it is clarified that a person shall be guilty of offense of money laundering if such person is found to have, directly or indirectly, attempted to indulge or knowingly assisted or knowingly is a party or is actually involved in one or more of the following processes or activities connected with the proceeds of crime. Now we need to understand what is proceeds of crime as well. Which activities are there? Concealment, possession, acquisition, use, or projecting as untainted property or claiming as untainted property in any manner whatsoever. The process or activity connected with proceeds of crime is a continuing activity, and it continues till such time a person is directly or indirectly enjoying the proceeds of crime by its concealment, possession, and all those steps which we have understood in the above clause. What is proceeds of crime? It means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense, or the value of any such property, or where such property is taken or held outside the country, then the property equivalent in value held within the country or abroad. So this line is taken outside the country. This was added later on by an amendment in 2019. It was not there earlier because it was not thought that PMLA will have to take into account the monies sent outside India, properties purchased outside India. So it provides for a very wide, how the coverage becomes wide here. If a property is purchased by the use of proceed of crime, which is the amount, which is the money or a property or an asset created or obtained from a criminal activity, if that property is located outside the country, for example, any immovable property is purchased or the amount is sent in a bank outside India, then the property equivalent in value held within this country shall also be considered as proceeds of crime. तो ऐसे जरूरी नहीं है कि the property which has been purchased by that money will be considered as a proceed of crime. Any property equivalent in value to that property may also be considered as the proceeds of crime. It is hereby clarified that proceeds of crime include property not only derived or obtained from the scheduled offense, but also any property which may directly or indirectly be derived or obtained as a result of criminal activity related to scheduled offense. So कोई scope नहीं बचता है, and that is why we are seeing a huge rise in the number of cases being filed under this act. Scheduled offense here has been defined as offenses specified under Part A of the schedule. So there are n number of offenses collected from various laws which are made part of Part A, Part B. And Part B earlier had the value of rupees 30 lakhs only. Now the value involved in such offences has been made to 1 crore rupees or more. Or C part is considering all the offences specified in Part A which are being spent in other countries outside India. What is the punishment for money laundering? Whosoever commits the offence of money laundering shall be punishable with rigorous imprisonment for a term of 3 years, but which may extend to 7 years, and shall also be liable to fine. And where the proceeds involved in the money laundering relates to offence specified in para 2 of Part A, the provision shall have the effect of which may extend to 7 years, which may in place of 7 years, it shall extend to 10 years. Attachment of property involved. So anyone can anyone just tell me if they are aware what kind of attachment it is? Because we have just seen that the punishment is fine or imprisonment. So what is this attachment? Shall I stop sharing?
Confiscation?
No. Confiscation has a different meaning under this act. We'll just come to that after one slide. So we have just read section 4 said that there is a punishment of so and so years and some fine and imprisonment and all that. But how and where this attachment comes into play?
where it could be proved that the property has been acquired through some illegal means or through proceed of crimes.
Yes, definitely. So PMLA works in two stages. One is the person behind that activity, the mind behind that activity has to be punished, right? Second, the property has to be attached. And attachment is also in three stages. It is not that today it is attached and it is confiscated and the ownership is gone. No, there are stages to that, and that also we'll cover in that presentation. So let's come back to section 5. Attachment of property in case involved in money laundering. Section 5 subsection 1 says where the director or any other officer not below the rank of deputy director authorized by the director for the purposes of this section. So now I'll read this as ED. Where the ED has reason to believe, that reason has to be recorded in writing on the basis of material in his possession, that any person is in possession of any proceeds of crime, and such proceeds of crime are likely to be concealed, transferred, or dealt with in any manner which may result in frustrating any proceedings related to confiscation of such proceeds of crime under this chapter. So ultimate aim is to confiscate the proceeds of crime or any property bought out of those proceeds of crime. So the person is in possession of any proceeds of crime, and that is likely to be concealed or shown as untainted proceeds, untainted money. He may, by order in writing, provisionally attach such property for a period not exceeding 180 days from the date of order in such manner as may be prescribed. So first stage is that he has a reason to believe such that proceeds of crime are there on the basis of material in record with him, and he has to give his reason to believe must be in writing. Thereafter he can provisionally attach such property for 6 months. Attachment here means prohibition of transfer or conversion or disposition or movement of property by an order issued under this chapter. So attachment here does not mean taking possession. Attachment here does not mean confiscation. Attachment here does not mean that the ownership starts vesting in government, maybe. Attachment only means that you cannot sell that, right? So there is a prohibition of transfer, conversion, disposition, or movement of property, and in case there is a risk of such transfer, etc., then in that case that is not a rule but an exception. In that case, if the ED has reasons to believe, he can also take possession, but that is not a rule, and that does not come under the definition of the attachment. The provisional attachment is only sending a notice that this property cannot be sold without our involvement, or you cannot just transfer that. Provided that no such order of attachment shall be made unless in relation to the scheduled offence a report has been forwarded to the magistrate under section 173 of the Code of Civil Procedures, or a complaint has been filed by a person authorized to investigate the offence mentioned in that schedule before a magistrate or court for taking cognizance of the scheduled offence. Provisos. Any property of any person may be attached under this section if the director or any other officer not below the rank of deputy director authorized by him for this purpose has reason to believe, that the reason has to be in writing, on the basis of material in his possession, that if such property involved in money laundering is not attached immediately, the non-attachment is likely to frustrate any proceeding under this act. Provided also that for the purposes of computing the period of 180 days, the period during which proceedings under this act is stayed by the High Court shall be excluded, and a further period not exceeding 30 days from the date of order of vacation of such stay order shall be counted. So such a liberal power is given to the ED. Impact of a set attachment. Every order of attachment shall cease to have effect after the expiry of 180 days or on the date of an order made under subsection 3 of section 8. Section 8 subsection 3 we will come to, which is the confirmation of the attachment, whichever is earlier. The director or any other officer who provisionally attaches any property under subsection 1 shall, within a period of 30 days from such attachment, file a complaint stating the facts of attachment before the AA. Now, one very interesting matter in this relation, the Honorable Supreme Court had examined the object and scheme of the legislation, wherein it was observed that Section 3 of PMLA stipulates money laundering as an offence involving proceeds of crime directly or indirectly. Further, the Honorable Court observed that Section 5 of PMLA describes the power of attachment of the tainted property involved in money laundering on account of reason to believe. And since the legislation does not provide the reason to believe phrase, the Honorable Court cited Section 26 of IBC, which states that if there are certain facts and circumstances which are enough to believe anything, we can say that the person has reason to believe. That means there must be facts and circumstances. As per the IBC, all the offences can be judged on the basis of knowledge, intention, or reason to believe. Now, what does Section 8 of PMLA says? On receipt of a complaint under subsection 5 of Section 5, that is the provisional attachment, or application made under subsection 4 of 17 or 18, if the AA has reason to believe that any person has committed an offence under Section 3 or is in possession of proceeds of crime, it may serve a notice of not less than 30 days on such person, calling upon him to indicate the sources of his income, earning or assets out of which or by means of which he has acquired the property attached under such sections, the evidence on which he relies, and other relevant information and particulars, and to show cause why all or any such properties should not be declared to be the properties involved in money laundering, and why they should not be confiscated by the central government. Please note that the central government has not yet come into picture, and the confiscation word has come for the first time, right? So there is no confiscation has taken as yet. The AA shall, after considering the reply, if any, hearing the aggrieved person and the director, the ED, and taking into account all relevant materials placed on record, by an order, record a finding whether all or any of the properties referred to in the notice are involved in money laundering. Where the AA decides under subsection 2 that property is involved in money laundering, he shall confirm the attachment of the property. Now here comes the word confirmation of attachment made under subsection 1 of section 5, because 5 subsection 1 was talking about provisional attachment, and 8 subsection 3 is the confirmation of attachment, which is made by AA. Or retention of property or record seized or frozen under section 17 or 18. Shall record a finding to that effect, whereupon such attachment or retention or freezing of the seized or frozen property or record shall continue during investigation for a period not exceeding 365 days. So from here starts the 1 year period during which investigation will take place, and the property will, the attachment on the property will be, is confirmed. So it is a confirmation of attachment and not the confiscation. So the
Madam, what about the 60 days timeline was prescribed in your last slide?
No, which one?
No, actually, I want to understand. See, what is the timeline for getting this confirmation? Whether the charge sheet kind of thing has to be filed before the AA in order to go for the confirmation?
So there is no timeline for the AA to come back. It has to consider the reply from the person, hear the aggrieved person and the ED, and take into account all relevant materials placed on record.
No, the timeline was 180 days in the last slide.
180 days was for provisional attachment. If by the end of 180 days, the confirmation of attachment is not made, then that will automatically cease.
Okay.
Right? So one is 180 days. Second is confirmation, which starts and after or during those 180 days. And this goes on till 365 days, or the pendency of proceedings, and become final upon the order of confiscation is passed. So that I've lost the track of what I was reading. Where the AA decides that any property is involved in money laundering, he shall, by an order in writing, he shall record a finding to that effect, whereupon such attachment or retention or record shall continue during investigation for a period of not exceeding 365 days or dependency of proceedings before a court or under the corresponding law of any other country, maybe before the competent court of criminal jurisdiction outside India, as the case may be, and become final after an order of confiscation is passed under subsection 5 or 7 of section 8 or section 58B or 2A of 60 by the special court. For the purposes of computing the period of 365 days under clause A, the period during which investigation is stayed by any court under any law for the time being in force shall be excluded. Subsection 4 says that where the provisional order of attachment made under subsection 1 of 5 has been confirmed under 8.3, the ED or any other officer authorized shall forthwith take the possession of the property attached under section 5 or frozen under section 1A of 17 in manner as prescribed. Provided if it is not practicable to take possession, then the order of confiscation shall have the same effect as if property had been taken possession of. Where on conclusion of a trial of an offence under this act, the special court finds that the offence of money laundering has been committed, it shall order that such property involved in a money laundering or which has been used for commission of the offence of money laundering shall stand confiscated to the central government. Now here comes the third stage, which is the confiscation, where on conclusion of a trial, special court finds that offence has not taken place or the property is not involved in money laundering, it shall order release of such property to the person legitimately entitled to receive that. Where the trial under this act cannot be conducted by reason of the death of the accused or accused being declared or proclaimed offender or for any other reason or having commenced but could not be concluded, the special court shall, on an application moved by the ED or the person claiming to be entitled to the possession of that property in respect of which an order has been passed under 8.3, pass appropriate orders regarding confiscation or release the property as the case may be involved in the offence. Where a property stands confiscated to the central government, the special court in such manner as may be prescribed may also direct the central government to restore such confiscated property or part thereof of a claimant with a legitimate interest in the property who may have suffered a quantifiable loss as a result of the offence. So that much portion, that part may be restored to the claimant who has a legitimate interest. Ultimately comes the section 9, which is the last and fourth step of the attachment, which is vesting of the property in central government, where an order of confiscation has been made under subsection 5 or 7 of the section 8 or so and so in respect of any property or a person. All the rights and title in such property shall vest absolutely in the central government, free from all encumbrances. Where the special court or AA, as the case may be, after giving an opportunity of being heard to any other person interested in that property, is of the opinion that any encumbrance on the property or the leasehold interest has been created with a view to defeat the provisions of this chapter, it may by order declare such encumbrance or leasehold interest to be void, and thereupon the property shall vest in the CG, free from any such encumbrances or leasehold interest. Now, one very important section is section 71 of PMLA that says the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. थोड़ा जाना पहचाना लग रहा है ना, लाइन हमारे 238 जैसा ही है बिल्कुल. तो the language is quite similar, the meaning is quite similar, both are non-obstante clauses, but important here is that many courts have taken the view, which will come later on, many courts have taken a view that whichever law is subsequent in time will have major impact on any conflict situation. So let us see how the things move on, but this clause is very much there under PMLA, and we have seen the importance of this law, why this is very important for the economy, for the nation, for the image of the nation, and overall micro and macro systems working under the larger ecosystem of the country, within the country as well as internationally. Continuation of proceeds in the event of death or insolvency. Any property of a person has been, where any property has been attached under section 8 and no appeal has been preferred, or where any appeal has been preferred to the appellate tribunal and the case referred to in clause A. Such person dies or is adjudicated and insolvent before preferring an appeal, or in case referred to in clause B. Such person dies or adjudicated and insolvent during the pendency of such appeal, then it shall be lawful for the legal representative of such person or the official assignee or the receiver, as the case may be, to prefer an appeal to the appellate, or as the case may be, to continue the appeal before the tribunal in place of such person. Right. Section 51A of UAPA. Now we are all aware of this act as well, Unlawful Activities Prevention Act 1967. This says for the prevention of and for coping with terrorist activities, the central government shall have the power to freeze, seize or attach funds and other financial assets or economic resources held by, on behalf of, or at the direction of the individuals or entities listed in the schedule to the order, or any other person engaged in or suspected to be engaged in terrorism. So these are why I have listed these points here, because we should understand why the financial crime and the money being flown to the terrorist activities, why and how much importance is being given to the subject. And even another law also gives similar power to the central government. PMLA gives the power to the ED, but this law gives the power to the central government. PMLA came into force in 2005 and was amended in 2009, and thereafter also it has been amended twice. The Unlawful Activities Prevention Act, UAPA, सब जानते हैं आजकल इसको, was amended in 2004 to criminalize the terrorist financing. The UAPA was further amended in December 2008 to broaden its scope and to bring the legislation more in line with the requirements of the UN Convention for the Suppression of Financing of Terrorism. Which are the authorities entrusted for investigation? Anyone, if anyone is having any idea, this investigating authority as a reference in our IBC also. Why we need to know the authorities entrusted here for investigation? No one?
With reference to
Yes.
investigating authorities could be like varied from act to act, different acts, including that Income Tax Act, GST Act.
Right. But what we are talking about is, we are talking about the investigating authorities under PMLA, and my question was how and where we are related with that while studying the corresponding law, the IBC. Where does IBC has this reference?
238A.
No. Exactly, the investigating authority is being used under section 32A. We'll come to that, and it is very interesting to know. So authorities are the ED, first of all, under the Department of Revenue, Ministry of Finance, Government of India is responsible for investigating the offences. Financial Intelligence Unit, that is FIU, India, under the Department of Revenue again, reporting directly to the EIC, headed by Finance Minister. It is a central national agency responsible for receiving, processing, analyzing and disseminating the information relating to suspectful financial transactions. It is also responsible for coordinating and strengthening the efforts of national and international intelligence investigations for pursuing the global efforts against money laundering and related crimes. The scheduled offences are separately investigated by the agencies mentioned under the respective acts. As I told you that the scheduled offences under PMLA are a collection of offences taken from crimes taken from various laws, and therefore the investigating agencies would then be coming out of those respective acts. For example, police, CBI, customs, SEBI, or any other investigative agency, as the case may be. The process. PMLA envisages a twofold measure, as I have told you. First, the attachment proceedings, which are under 3 stages, wherein the property is suspected to be the proceeds of crime are attached. Second, the prosecution of the accused through a special court with the intended goal of punishment. Under PMLA, two proceedings run simultaneously. One is attachment and seizure, and second is the criminal prosecution of the accused by the session court. So this is very important to be understood. Civil court shall not have any jurisdiction, and here all of us are aware that the AA is the High Court. High Court means High Court within jurisdiction of which the agreed party ordinarily resides or carries on business or personally works for gain, and where the central government is the agreed party, the High Court, within the jurisdiction of which the respondent, or in case where there are more than one respondents, then any of them ordinarily reside, carries on business or personally works for gain. Bar of suits in civil court: no suit shall be brought in any civil court to set aside or modify any proceeding taken or order made under this act, and no prosecution, suit or other proceeding shall lie against the government or any officer of the government for anything done or intended to be done in good faith under this act. Adjudicating authority also was a confusing question earlier, unless it was set to rest by applying the principles laid down by the Supreme Court in Ambika Industries and L. Chandra Kumar, and considering the fact that the first court, that is AA, is situated in Delhi and exercises pan-India jurisdiction, and that even the appellate tribunal is also situated in Delhi, the Delhi High Court would be the forum convenience. That is the convenient place. But ultimately, it is a petitioner's choice of which forum that he has chosen. The choice of forum that has to be respected, as has been laid down by the apex court in a number of cases. So petitioner may choose to file his petition from the other high courts as well, other than Delhi also.
Ma'am, could you just explain a bit about the process you have made us understood? There are two way, like, this process goes on. So that the court is situated at PMLA, that is a special court in Delhi, right? So an appellate authority is also there.
Yes.
So
appellate, yeah.
So where comes, like, High Court in picture?
The petitioner may choose to go to High Court.
That means I have the right petitioner. That means ED, right?
Yes, ED can also start from there, and the petitioner against the order of the appellate of PMLA can go directly to the High Court.
Okay, that means
appellate is also High Court.
Appellate is also High Court.
Yes. So this is very interesting case. If you go through this Ambika Industries and L. Chandra Kumar, this is an interesting case, and they also finally have a caveat that it is a petitioner's choice of forum, but forum of convenience would be Delhi. So now my question, and there is no camera on except for one person. Chalo koi baat nahi. My question is, where do we see, now we have understood PMLA in depth. Most of the cases which, most of the sections which pertain to us during any work with any CD, most of the definitions are clear now. So where do we see a difference? Not the difference, there are different. What are the similarities under two acts? Are there any?
Which two acts?
IBC and PMLA we are talking.
Okay. Can we say that both are civil court?
No.
Civil jurisdiction, no.
Both are codes complete in themselves, which contain the substantive as well as the procedural law. Is that the similarity?
Maybe, yes. This is not a very formal question. Actually, there is no written answer to it. I'm just talking out of nowhere. There is one very important hindsight fact about both the laws, which I found very interesting while doing my research, but no one will accept that formally. Their objectives are different, their procedures are different, AA is different, Ultimate preamble is different. Process is different. Timelines are different. Professionals involved are different.
So far objectives are concerned, both runs parallelly. Like, if you see that IBC and PMLA, the objective remain the same, like, just to maximize the value of the corporate data. So far, the corporate data is concerned.
No,
And
PMLA does not have that objective at all.
Some way
punishment could be the added along with that.
Maybe it can be said that the proceeds, especially when it comes to the buffet transactions, the beneficiary is the same. The promoters could be the beneficiary in this case and could also be the guilty party in PMLA.
Sujata ma'am, you started correctly. Buffet transaction is one such area where some proceedings may collide, but the beneficiary is not the promoter in either of the.
Yes.
No. What I meant was in a buffet, in most of the cases, the beneficiary is the promoter, and in case of PMLA, of course, the beneficiary of the proceeds of the crime could be the promoter. I did not mean the.
No. In PMLA, whatever is recovered or taken back or confiscated from the accused is vesting in central government. So that
Correct. No. What I will repeat myself again, that in the buffet transaction, in most cases, the promoters are the beneficiary, and under PMLA, they are the ones who are, holding on to the proceeds of crime.
proceeds, right?
That is what I mean.
Yes, you are right. That's a fact. Anything else coming to anybody's mind which we say, no, this is not our objective, but in the hindsight, it is the objective somewhere. Not the objective, but the outcome of the process. The process carried out under PMLA and the process carried out under IBC would lead to something.
Yes,
not
taking
felt
away,
effective.
taking it away from the hands of the perpetrator, both in IBC and in PMLA, the wrongfully gained amount or the property is taken away from the perpetrator.
That is very well described, ma'am. I didn't have that perspective in my mind and I was coming from somewhere else. So there is one more similarity in both of them. So let me tell you, when we say the aim is not recovery, in IBC, everywhere, every chapter, every academician, every forum, it is said aim is not recovery. So ultimately, when the process is successfully handled, CIRP is reached or the liquidation is properly done. So what is it that we reach to? We reach to a recovery, right? So that is also checked how much haircut has been given, how much recovery has been made, right? So in the height side, there is something being measured in terms of recovery. And in PMLA also, aim is to prevent such activities, then stop the proceeds of crime to be integrated into the system, stopping to make it legitimate money, untainted property, but then all such proceeds of crime and all the properties bought directly or indirectly out of such proceeds are taken back by the central government and there is a recovery. And the measurement of success of PMLA implementation is how much recovery they have made. So that is something which is not there formally, but ultimately both of them result in recovery. Am I correct?
Ma'am, how would you distinguish it with suppose some of the cases has landed in CBI?
Okay. So
So how this objectivity, transpires or travels from one statute to other?
see, CBI is a special wing doing its job in investigating whether that fraud has taken place, for example, or a complaint has been referred to CBI, then it has a specified job of finding out the truth behind that incident, right? So I don't understand what is the question here, but every agency, every investigating agency has a specific role assigned to it, and on the cases referred to them, they perform their role in that capacity.
But in many times, like, the CBI cases, like, they also refer the case to PMLA.
Why? Because PMLA, when CBI thinks that a crime has taken place, from that crime money has been generated, though that money has been used to create property or buy assets, jewelry, immovable assets, or money has been sent abroad. If that is the fact in any crime, so that for that money, CBI cannot follow that channel of finding out the way where the money has gone and which route the money has taken. So in that case, for that much, the matter is referred to ED as well. So ED also starts its investigation parallelly.
It could travel from SFI also, right?
SFIO has its own role.
So-
All have their own specific roles. When the matter relates to simply a fraud, maybe journal entries are wrongly placed or no money is involved. Money has been money has changed hands, but no such fraud is a crime covered under that PMLA as well. But from that fraud, the money has not changed hands and the properties are not bought out of it.
So can we say that the preliminary investigation is done by agencies such as CBI, but having reached some kind of a conclusion, then it moves on to a more specific investigation, for instance?
No, I don't
PMLA.
think. I don't think. Sometimes both of them are started parallelly. They are started by PMLA, under PMLA first sometimes. So it is not necessary that there is a case matter for CBI, then only it will be referred to PMLA. PMLA has a long list of scheduled offences under its under Part A, B, and C, which is much more than the CBI's scope of work. And PMLA also has the provisional after the provisional attachment during the initial investigation of 6 months. They have to make a conclusion of those 3 steps, that the proceeds have been generated out of such crime, right? Crime has taken place, proceeds have been generated, and thereafter those have been used to be shown as legitimate money. And then wherever that money has been spent, or even if it is lying in the bank, that money is the proceed of crime, which is to be proved by them. Right?
So the integration has happened.
Yeah.
Finally.
Yeah. Because showing that money as a legal money and untainted property as the law has used. So that untainted ko show karna, projecting it to be an untainted property is the crime under PMLA. Which is arising, the money which has come out of illegal activity, but you are showing it to be a legal money in the hands of some other person who might have taken that. That carve out is also there. If somebody has bought a property under in good faith, without knowing that it has changed hands from some illegal source, and he has paid consideration at par with the whatever market value, or maybe if he can prove his genuinity, the transaction is at a proper consideration and all those good faith parameters are proved, then he is eligible to take he is entitled to the right in that property, even after PMLA has confiscated, the central government has confiscated that property. The right of a genuine bona fide buyer may be proved. So that carve out is also given under PMLA, because the person may not be knowing it might have changed so many hands. So
Good faith and for
Yes.
valuable consideration.
Yes. That is given due importance. That has been given due importance in the PMLA also. So let's come back to our own IBC. So section 14, we are all aware. Do you want me to go through the text, or we go ahead?
We should go ahead.
Okay. At least some people are awake. So the explanation is also there, which we are aware. It shall not apply to such transactions, agreement or notified by the central government. The purpose. Moratorium facilitates and gives space for negotiations. It gives the creditors and the CD the opportunity to apply their minds without any additional stress during the CRP. Additionally, it gives them the chance to deliberate upon the viability of the revival of the corporate entity. The declaration of moratorium prevents the company's assets from downfall, enabling the corporate entity to continue with its operations without the fear of judicial interventions. Thus, the moratorium seeks to reinforce its legislative wisdom, that is, providing value maximization. Now, the most important is section 32A. Let's go back to moratorium. If anyone has a view, let's discuss the main agenda of today's discussion. Let's have our views. 2-3 views we can take, whether section 14 prevails or ED attachment will prevail. Hot question of today's discussion. Then we'll go to see what courts have to say.
First of all, as per section 14, we need to preserve the assets of the corporate data. See, we have to see, like, we have to judge and we have to see whether there's incumbency on the properties or some attachments are there. If that is there, that we should endeavor to, take the recourse of that by, hello.
Yes, I'm there. See, for a fraction of second the video is off and you think I'm not there. तो सोचो कितने सारे लोगों का video हमेशा off रहता है. 45 people, I'm just looking at their names.
Yes.
हाँ जी.
You rightly, like, in your slide mentioned that, okay, the main purpose of moratorium is to just to make a fence around the corporate data so that all the stakeholders should come together and try to evaluate things, like, from there on.
But most important question, whether the attachment should continue or not.
Attachment should not continue.
Okay, any other views?
If attachment is continued, there will be a deadlock.
May not be. There is a case where the RA and the plan was also approved, despite the fact that RA was aware that all the properties of CD are under attachment, confirmed attachment by the ED. Even then the plan was approved.
So that means they are taking a chance out, taking the risk.
No, they might be aware.
Contingent, yeah.
They are taking the risk.
You see, if there is an attachment, how can the company or corporate data continue as a going concern?
Right. So we are all thinking from IBC perspective only and not thinking about the larger public interest, which is being imposed by the government through its policies and this huge heavy law PMLA. So we don't agree with that. Anyone who is agreeing that PMLA attachment by the ED can continue or should continue, anyone is having that view? इतना PMLA पढ़ा हमने, हम इन
हाँ, वो एक दूसरा theory ये हो सकता है कि जो अभी है, because उसका title clear नहीं है. Title clear नहीं है, मतलब वो अभी उसका दिख नहीं रहा है कि, लेकिन whether it could be crystallized or it will come in the pool.
Definitely, RA will not get attracted easily.
But RA is taking chance to, like, is making an offer. Seeing the health of the corporate data.
Yes, I have seen people.
तो मैडम उसके लिए बोनस रहेगा ना, अगर मिल जाता है बाद में, because वो resolution plan में वही रहेगा कि वो जो भी कुछ आएगा वो
resolution plan को discounted दे देगा और बाद में बोनस मिल जाएगा. You are right. Sir, I also have many senior people participating. So having your views will be a delight.
Yes, Harmeet ma'am, basically, although the section 32 gives a immunity to the RA as well as the very person buying those property even in liquidation, but the judicial pronouncements have a very different views. Okay, still now although the matter is pending with our apex court, Supreme Court, as you know, it is to be finally to be decided. But many high courts have given the verdict that for this we must approach to the PMLA courts, and NCLT does not have jurisdiction to decide on these issues. And as far as this moratorium is concerned, there is a view of the court, mostly of the courts, that moratorium does not made applicable for this criminal transactions, which are basically criminal transactions. So that's the reason all of us as a RP and liquidator, we are fighting we are making our efforts to get those properties back so that we can complete this process of whether CRP or liquidation. But the matter is still pending with the courts because, to my knowledge, what I feel that NCLT is not well equipped or well competent to issue these orders, even when it is covered under Section 14 moratorium. So that is the matter still to be disputed, and not the complete clear picture is not available with us. Okay, and definitely you must be having specific cases for this, which you please.
I will. Thank you so much.
No, but one more opinion is that, if these assets are acquired out of proceeds of crime, then obviously the attachment is justified.
Yeah. So first person in my league.
And actually, I fully agree. But the matter is that when the attachment is there, but basically it is yet to be finalized whether
Yes.
it is actually acquired out of proceed of crime or not.
Yes.
So since the matter is not yet been decided, so we cannot conclude. That is another aspect, major aspect. One is decided, one is court has given the verdict that is a proceed of crime, and definitely they have got the full right on it.
Very important point. Very important point. Yes. Anyone else having any personal view on the subject? So it is a taint on the image of the CD, even if later on it is decided that the asset has not been purchased out of the proceeds of crime. Right? Let's go ahead with section 32A, very important section. So I'll just go through it quickly. It says, notwithstanding anything to the contrary contained in this code or any other law for the time being enforced, the liability of a CD for an offence committed prior to the commencement of CRP process shall cease, and the CD shall not be prosecuted for such an offence from the date of resolution plan has been approved, and there is a change in management and control of the CD. Provided that if a prosecution had been instituted during CRP period against such CD, it shall stand discharged from the date of approval of the plan, subject to the requirement of this subsection being fulfilled. That is, there must be a change of the management. No action. Other point. So 32A also has 2 points to say. Similarly, PMLA also had 2 areas, 2 actions. Similarly, here the property is also saved. The property of the CD in relation to an offence committed prior to the commencement of CRP, where such property is covered under a resolution plan approved by the AA, which results in change in control of the CD to a person, or sale of liquidation assets under the provisions of Chapter 3 to a person who was not a promoter or a related party to that promoter. Right? So the property of the CD as well as CD have got this immunity. Now they say a person with regard to whom the relevant investigating authority, here comes the investigating authority. So we must be aware that which investigating authority is coming out of which law. Where a person with regard to whom the relevant investigating authority has, on the basis of material in its possession, reason to believe that he had abetted or conspired for the commission of the offence and has submitted or filed a report or a complaint to the relevant statutory authority or court, in that case, this immunity shall not be available under both the subsection 1 and 2. Subsection 3 says, notwithstanding the immunity given in this section, the CD and any person who may be required to provide assistance under such law as may be applicable to such CD or person shall extend all assistance and cooperation to any authority investigating an offence committed prior to the commencement of the CRP. So this immunity has been a boost for IBC because many RAs were refraining to file any, to give any plans to come and take any CD, acquire any CD or any business because of such prior period offences. We are all aware how and how much this 32A has helped IBC. The success in IBC. There can be no attachment of assets of a company when it is undergoing a moratorium. This amendment has been beneficial for the investors of the company as the illegal properties can be utilized to settle their claims. It also absolves the CD of all the criminal liabilities and all claims of seizure, attachment, confiscation, etc. For example, if the promoters or the old management have invested the proceeds of crime in the business itself, and the business is running into losses, and thereafter the CRP is commenced, so they are very well, absorbed of those activities, those liabilities. Thus, many academicians agree that the introduction of Section 32A has settled the position of law and has cleared the IBC proceedings, that it will override the PMLA prosecution. Some theorists still think that 32A is overriding the PMLA. It shows the intent of legislature that an alteration in the hierarchy of government dues was one of the primary objectives of IBC. Now, here there is a catch. The PMLA action, the attachment by the central government, does not make central government a creditor. So here, this theory does not fit well. Impact, it refers to a scenario that would arise after filing of a resolution plan only. However, if the ED is allowed to interfere prior to that, then no RA would be encouraged to submit. So this impact we are aware of. The provision does not provide what all regulatory bodies fall under the category of investigating authority. The issue that arises due to this vague definition is that whether an approved resolution plan can exonerate the CD from all other criminal liability claims like negotiation instrument or FEMA violation or SEBI, etc. One of the significant implications of this amendment is that it is not a permanent solution for any of the parties. The amendment protects the CD from attachment till CIRP is completed. Once it is done, the ED can proceed with the attachment and thus leaving the company high and dry again. The CRP would not be of any use in that case. And this 32A has given escape to some offenders. For example, it also provides an escape route to the management, who obviously have a sense that financials of a company are going down and they have a prior knowledge if there is a possibility of CRP. Even the one application is filed and thereafter they are aware of the CRP maybe initiating in 6 to 8 months. Taking advantage of this knowledge, they may commit the criminal offense like money laundering under the impression that they will get an advantage of Section 32A. At least the property of the CD will get an advantage if they are successful and the plan is approved ultimately. All the illegal proceeds would be legalized. The provision is also unclear as to the fact that what will be the solution if ED proceedings are already going on when the CRP begins. In the matter of P. Mohan Raj and others versus Shah Brothers Ispat Private Limited, Honorable Supreme Court has held that Section 32A cannot possibly be said to throw any light on the true interpretation of Section 14(1)A, as the reason for introducing 32A had nothing to do with any moratorium. At the heart of the section is the extinguishment of criminal liability of the CD, only CD, from the date the plan is approved by the AA, so that the new management may make a clean break with the past. A moratorium provision, on the other hand, does not extinguish any liability, civil or criminal, but only casts a shadow on the proceedings already initiated and the proceedings to be initiated, which when the moratorium is lifted, then the shadow is also lifted. Section 32A(1) operates only after the moratorium comes to an end. At the heart of 32A is the IBC's goal of value maximization and need to obviate lower recoveries to creditors as a result of the CD continuing to be exposed to criminal liability. SC also held that 32A is not elegantly drafted. The second proviso speaks of persons who are in any manner in charge of or responsible of the CD for the conduct of business or associated with the CD, and who are directly or indirectly involved in the commission of such offense, that is the offense referred to in subsection 1, as per the report submitted or complaint filed by any investigating authority. The report submitted here refers to a police report under section 173 and complaints filed by the investigating authorities under special acts as opposed to the private complaints. So there are many areas which are loosely left in the language of the section. If the language of the second proviso is taken to interpret the language of 32A(1) in that the offense committed under 32A(1) would not include the offenses based on complaints under 2D of CRPC, the width of the language would be cut down And the object of 32A1 would not be achieved as all prosecutions emanating from private complaints would be excluded, because investigating authority is not there under the private complaints maybe. Obviously, 32A1 cannot be read in this fashion and clearly includes the liability of the CD for all the offences committed prior to the commencement of CRP. Section 138 proceeding would be included. This was a matter of section 138. So it has been derived that 138 proceeding would be included and would, after the moratorium period comes to an end with a resolution planned by a new management being approved by AA, then CD, it will not be an offence against the CD, and 138 proceedings will cease to have an effect against only the CD. Now, what is the implication of 238? We are all aware of the text of 238, and we also read the text of section 71 under PMLA. Both the enactments have non-obstante clause, both of which give a clear overriding effect to both of them, IBC as well as PMLA. However, Supreme Court in the case of Maruti Udyog versus Ramlal has held that if two special statutes have a non-obstante clause, the one which is enacted later will prevail over the earlier one, easiest interpretation. The reasoning for such a conclusion is that the legislature, while promulgating the latter act, had the knowledge that a previous act containing a non-obstante clause already exists, right? So one is this easy way. There are many judgments which support the fact that IBC prevails over other acts, right? So there is no doubt about it. We are all aware about that. But when it comes to PMLA, the matter stops at SC. As we are aware that there are many appeals filed with Honorable Supreme Court, and all of them are just kept in abeyance because the SC has directed the CG, the government, to find out some via media from where the exact position can be brought out. The intent of both the laws are different, the objectives are different, and one cannot be just decided to be having overriding effect of over the other. So a via media is being generated, rules are being laid down, and thereafter SC will come with its verdict. Section 71 of PMLA Act is prior in time, while Section 14, 32 and 238 are latest will of the legislature. This is still continuing from the Supreme Court verdict. There is an express statutory provision in the form of 32A of the IBC, which is based on a clean slate approach, which not only protects the new management from criminal liability of prior offences, but also takes out the assets of the CD from coercive action in relation to offences committed prior to the commencement of CRP. You know what is happening these days now with the literal interpretations of these two acts. What happens is PMLA overrides IBC, right? And then they wait till the plan approval. When the plan is approved, then the assets are freed from the coercive actions of the ED. And then the RA enjoys the title in them. So this is happening on the basis of the literal interpretation right now, and which is a great confusion. The object of IBC is the effective revival of the CD. It is submitted that this objective shall stand completely defeated if the RP is not given the charge of the properties, and even higher damage if the RA is not given the complete business assets. Section 31 of 1 of IBC was amended in 2019 to confirm that once a plan is approved, it is binding on all the stakeholders, including central governments, all statutory authorities. So it should be applicable on ED as well. Clean slate theory again supports the same fact that the intention behind insertion of these sections was to protect the assets of the CD during CRP period, and thereafter giving the clean slate, the clean state of affairs to the new management. Therefore, the true essence of 32A can only be appreciated by making CRP immune from any such impediments being offered by all the laws which are applicable to the CD. Further, the court envisages that resolution applicant who acquires the rights in the CD ought to be able to enjoy the assets free from any obligations. That is the theory we read under Ghanshyam Das. There are certain other cases also emphasizing the clean slate theory. The court emphasized that a successful resolution applicant should start with a clean slate based on his approval plan. Similarly, Supreme Court in Manish Kumar versus Union of India has extensively dealt with this issue in context of Section 32A. In similar case of JSW Steel, this is very interesting. One must read the entire story of JSW Steel. The stand of Ministry of Corporate Affairs was very clear that the intervention of the ED or any such authority would have a negative impact on the entire CRP process. The Telangana High Court in Messrs. Satyam Computer validated that after one wing of the government, that is the NCLT, had induced the third party like the strategic investor to come to rescue the company, and another wing of the government, that is ED, that cannot take an action that will vitiate the entire process. So there are many views being given by various authorities, ministries, courts, NCLTs. All of them have various different views, and it is very interesting to know the views of different forums, and we'll be seeing them now onwards. I have taken some judgments from relevant to the context, but important is still to the fate of the matter ultimately lies in the hands of Supreme Court as yet, because we cannot decide, and I'm sure you can see even the High Court, even the NCLT, LAT are not able to decide in the best manner possible, and some route has to be created, some caveat has to be introduced for making this happen, because PMLA is of national and international importance for the country. IBC has taken India to an international pedestal in ease of doing business, so government cannot compromise with either of them. So in Bhushan Power and Steel matter, what happened? The ED claimed that some of the assets owned by Messrs. Bhushan Power and Steel were in the nature of proceeds of crime, and hence they had the power to attach the said properties. JSW moved to the tribunal to seek redressal on the issue that whether ED had the power to attach the property when the plan has already been approved. NCLAT ruled that ED will have a claim on the property in the nature of operational debt. Actually, the ED or the central government getting back any recovery or recovering any assets or taking into possession or confiscating the assets purchased out of the proceeds of crime do not become a creditor. They are imposing punishment, they are imposing fines they are penalizing the wrongdoer. They are not the creditors. But there are theories available. After the insertion of 32A, NCLAT held that the plan submitted by JSW stands approved and the amendment provides blanket immunity to them, thereby flagging all the criminal prosecution against the CD, flagging off. However, this decision of NCLAT has been challenged by the ED in the Supreme Court. A similar issue was faced by SEBI when it passed an order for attachment of assets of a company. Subsequently, CRP was initiated and there was a conflict of interest. The NCLAT held that due to Section 238, the code will override. Right? In the same matter, JSW, NCLAT held that in the light of the whatever proceedings were there in the judgment, the ED, while conducting investigation under PMLA, is free to deal with or attach the personal assets of erstwhile promoters and other accused persons acquired through crime proceeds, and not the assets of the CD which have been financed by the creditors and acquired by a bona fide third party RA through the statutory process supervised and approved by the AA under IBC. Insofar as a RA is concerned, they would not be they would not be in a wrongful enjoyment of any proceeds of crime after acquisition of the CD and its assets, as an RA would be a bona fide asset acquired through a resolution process, a legal process. Therefore, upon an acquisition under a CRP by the RA, the CD and its assets are not derived or obtained through proceeds of crime and need not be subject to attachment of ED. So this was the theory. This was the reason given by the NCLAT. The Union of India had invocably stated that after the completion of CRP, there cannot be any threat of criminal proceedings against the CD or the attachment after the approval of plan. So this derivation is from 32A. In any event, by virtue of Section 238, the IBC has an overriding effect over anything. So this is all covered under the NCLAT judgment, and the matter is pending with Supreme Court. In the matter of Prashant, I cannot see this. And diamond power. This is very interesting matter. Here, the NCLAT said that section 32D speaks about the implementation and supervision of plan, whereas 32E speaks about whether the plan contravenes any of the provisions. The RP has certified that the plan does not contravene any provisions of law. We also do not find any conditions set out by the RA which is against the provisions of law. But one question we have to consider very seriously, that the assets of the CD are attached by ED and that proceeding is still pending before the Honorable Supreme Court. It appears to us that the RA was aware of this fact that assets are attached, and despite that, it has submitted the plan. The statement made in the plan stating that the successful RA will appear in the SLP pending before the Honorable Supreme Court would show that the attachment is illegal. Be that as it may, the controversy is still pending before the Honorable Supreme Court, and we have nothing to say about it. That NCLT held while approving the plan. This is the part of the final order of NCLT while approving the plan. They say that the RA has acknowledged the fact, he is aware that the assets are attached by the CD. Then they say we do not see any reason per se to hold that the plan is against the provisions of law. We have to consider whether the plan could be implemented because the assets are under attachment. It is seen from the evidence on record that the RA is ready to make payment to the extent of 501 crores, and that too within a maximum period of, within a period of 6 to 60 months, and the COC in their commercial wisdom have approved the plan. If the RA fails to implement, then any person who is prejudicially affected will invoke the provisions of 33(3), which states that if the plan is approved, any person other than CD whose interests are affected may make an application for liquidation, etc. So they have taken note of the fact that RA is aware, even then it has agreed to give the plan. COC has approved the plan, and RA is also stating, writing in the plan itself that it shall be appearing in the SLP pending before Honorable Supreme Court to show that the attachment was illegal. It shows that RAs have also started understanding where the company is standing right now. So this matter is quite interesting. The resolution applicant has to comply the agreed payment schedule to the various creditors. NCLT को और कोई लेना देना नहीं था, उनको बस ये था आप इम्प्लीमेंट करो, नहीं करोगे तो किसका भी इंटरेस्ट प्रिजुडिशियली अफेक्ट होगा, दे विल बी फाइलिंग लिक्विडेशन का एप्लीकेशन. सो दे जस्ट अप्रूव द प्लान. Now this friction, the CD and its erstwhile management involved in the scheduled offences as prescribed under PMLA and proceedings have been initiated in terms of PMLA simultaneously to the CRP has been initiated in order. Then both proceedings shall create friction. ये friction तो आएंगे till such time we get a clarity under the law by the government, and some clarity can be brought down by the Supreme Court. So I think we can take a break at this stage. Ankita, are you there?
Yes, ma'am.
Can we take a break of 10 minutes?
Yes, ma'am, we can take a break. We can come back at 4:45, if that's
Sure.
okay.
Yeah. Thank you so much.
Okay, ma'am.
Okay, Ji. area of our discussion, the second part, the case laws. In the upcoming slides, you will be seeing a variety of decisions taken by different courts. जिसको जो मन में ठीक लगा उसने उस टाइम पे वो दे दिया, अगले दिन नहीं ठीक लगा, नेक्स्ट ईयर आया, नेक्स्ट ईयर तक अपना ही वर्डिक्ट चेंज कर दिया. The views of even the same person, same judge, same member are changed over a period of time. So it is very interesting to see how the government is tackling this subject. So this scuffle is that where both PMLA and IBC could be applied, there is an uncertainty and lack of transparency as to how the provisions should be applied. On one hand, an argument can be taken that if PMLA is not applied, then this would result in manipulation of the immunity and moratorium provisions to get away from the crime of money laundering by the offenders. However, this argument is more academic and it has not happened so far in any noticeable manner, but it is very well a possibility. And the criminals always find a loophole in any law. The other argument is that it hampers genuine business acquisitions under IBC and affects the time value of money, and it can possibly make projects unviable as the cases can linger on in the court for years. Now, in the ED versus Axis Bank matter, Honorable High Court of Delhi had rejected the fact of prevalence of other laws over PMLA. So, the PMLA prevailed over IBC as per the view of Honorable High Court. It was held that accepting moratorium and other immunity provisions of IBC would defeat the objective of PMLA by opening an escape route for the offenders, because the property purchased out of the proceeds of crime will get legitimized after the plan is approved or a genuine sale is made from a liquidation process. A person indulging in money laundering cannot be permitted to avail of the proceeds of crime to get a discharge for his civil liability, as such assets are part of proceeds of crime and subject to confiscation. Vijay Madanlal Chaudhary and others versus Union of India and others. The Honorable Supreme Court on 27 July 22 held that money laundering is an independent offense under PMLA. It is sufficient that if a person is involved in processes or activities connected with the proceeds of crime as specified under Section 3. All of them are treated as one class of offenders involved in money laundering. It is not important whether the offender is involved in a predicated offense or not. So now this is a very technical term under the PMLA. Predicated offense has been explained by Supreme Court later on. This has increased the scope of attachment assets acquired by the successful bidders too under approved CRP. What happened in this matter was, over the years since its inception, it was believed by the individuals facing charges under PMLA that certain provisions of the statute were arbitrary, disproportionate, and violated the rights of accused persons guaranteed under the Indian Constitution. So in July 22, SC pronounced its judgment in a batch of writ petitions challenging the various provisions of the statute. A batch of matters were ranging from special leave petitions, appeals, and writ petitions were filed before the SC over the past decade and a half. Various provisions of PMLA, including the constitutional validity of the same, were challenged. Some were born out of the orders passed by High Court or subordinate courts, rejecting applications for discharge, bail, quashing, etc., without delving into the factual matrix of each case forming part of the batch. The SC restricted itself to answering the questions of law challenging the provisions of PMLA. It held that projecting or claiming the proceeds of crime as untainted property is an independent act of indulging in money laundering, and that it need not be coupled with concealment, possession, acquisition, or use of proceeds of crime. So that brought light to the basic definitions of PMLA. It was also clarified that to proceed against an individual alleged to have committed offences under PMLA, a predicate offence, that is, an offence based on which proceeds of crime were generated, must have been registered with the jurisdictional police or before the competent forum. An action for provisional attachment of property can be initiated only on the basis of material in possession of the authorized officer, indicative of a person being in possession of proceeds of crime. Only those properties which appear to be proceeds of crime could be attached, and not all properties belonging to an accused. The provision relating to burden of proof in any proceeding relating to proceeds of crime under PMLA apply to the proceedings where both the AA with respect to attachment of properties and criminal proceedings before the special courts. The legal presumption of guilt under PMLA is about the fact that proceeds of crime are involved in the money laundering, which however can be rebutted by the person accused by producing evidence within his personal knowledge. So the natural legal presumption has reasonable nexus with the legislative intent under the PMLA. It also finds is the predicate offense was also described by the finance minister, the then finance minister, Mr. P. Chidambaram, while introducing the PMLA in Rajya Sabha on December 17, 2012. Money laundering is a very technically defined offense. It is not the way we understand money laundering in a colloquial sense. It is a technically defined offense. It postulates that there must be a predicate offense and it is dealing with the proceeds of a crime. That is the offense of money laundering. It is more than simply converting black money into white or white into black. That is an offense under Income Tax Act. There must be a crime as defined under the schedule of PMLA, and as a result of that crime there must be certain proceeds. It could be cash, it could be property, and anyone who directly or indirectly indulges or assists or is involved in any process or activity connected with the proceeds of crime and projects it as a legal property is guilty of offense of money laundering. So it is a very technical offense. The predicate offenses are all listed in the schedule. Unless there is a predicate offense, there cannot be an offense of money laundering. Supreme Court on predicate offenses, what they have said, in the event a person is acquitted in relation to the scheduled offense who rightfully owns or possesses an alleged tainted property, then such a property cannot be termed as a proceed of crime. The natural consequence of such understanding is that in the event there are no identified proceeds of crime, the authorities under the Act, being ED, cannot step in or initiate any prosecution. You know what happened as a result of this judgment of July 2022? Tens of matters where people were not being granted bail and their properties were attached or even confiscated were released out after this judgment, because there was no nexus in the property purchased legally, and the proceeds of crime. While the whole quantum of tainted property need not be regarded as a proceed of crime, the property qualifying under the definition clause of 2U of the Act will necessarily be treated as crime property or laundered property. Now we come back to our IBC versus PMLA battle once again. In Natala Sampat Jewelry Private Limited matter, what happened versus ED, of course, NCLT first addressed the battle of primacy in a liquidation order passed wherein the tribunal observed that this liquidation order will in no way affect the money laundering proceedings going against the promoters of the company. The next in line was Deputy Directorate of Enforcement at Delhi versus Axis Bank, wherein the Delhi High Court held that the objectives of the two enactments are completely different and hence the court should provide a harmonious construction of the said provisions. The IBC will not prevail over PMLA. In case if any third party has any prior claims on the attached property, the party will have to establish that they had no knowledge of the crime and the special court will adjudicate upon their charge. In Rajiv Chakrabarti versus ED, Delhi High Court judgment dated 11th November 22, which has been the most recent one, which has been under discussion so much so that the write-up has we are having this text of the judgment by heart by now. Via this judgment, the Honorable Delhi High Court in case of Rajiv Chakrabarti versus ED observed that the ED under PMLA is entrusted with the authority to attach a CD's assets perceived to be proceeds of crime, given that the embargo within the ambit of Section 32A is not attracted. The aforesaid decision has brought into light the never-ending scuffle between the two laws and the question of dominance. In the present case, the Honorable HC paved the way for ED and noted that the intent and objective of the moratorium provision incorporated in the IBC is that it principally subserves the purpose of preservation of assets of the debtor. Enables all stakeholders to explore the possibility of revitalization, and if ultimately all those efforts fail, for its expeditious liquidation. Thus, the purpose of a moratorium is clearly distinct from the purpose or objectives of attachment action taken under PMLA, which is not concerned with the recovery or enforcement of a debt. Proceedings for attachment that may be initiated in terms hereof cannot be viewed as being similar to an action for enforcement or recovery of a debt. It is not a debt. The Honorable HC has also noted that the moratorium would not prevent the authorities under PMLA from exercising the powers conferred by Section 5 and 8 of PMLA, which now we are aware, notwithstanding the pendency of CIRP. That means PMLA attachment is distinct action and shall take place irrespective of the ongoing CIRP. While proceeding to attach the tainted property, the respondents were not, in a sense, effacing the property rights that may be claimed by an individual. It is a symbolic taking over of the custody of the property and for its preservation till such time as the proceedings that may be initiated in a PMLA come to a conclusion. Thus, attachment is not liable to be viewed as an effacement of the rights that may exist or be claimed to be exercisable in respect of property. It is essentially an action aimed at bringing into control of a court or an authority the property over which attachment does not result in effacement of rights. It would clearly stand and survive outside the scope of a moratorium or an action relating to an action in respect of a debt due or payable. So those actions are not having any effect on a property which is attached. The Honorable HC opined that, however, both the orders under 5 and 8 of PMLA remain orders of attachment. The passing of those orders do not result in confiscation of properties, nor do these properties come to vest in the union government upon such orders being made. Thus, the attached property comes to vest in union government only upon the passing of an order as may be passed by the special court, either under 5 or 7, subsections 5 or 7 of section 8 or 58B or 62(2)(a). This concludes that the provisional attachment of properties would, in any case, not violate the primary objectives of section 14 of the IBC. Does that make sense? Yeah, there is some logic behind this as well. तो अभी कोई लोग आए वापस PMLA के side? I had only one person with me. चलो और देखते हैं. So there is logic behind this thinking as well. तो क्योंकि right affect नहीं हो रहे हैं, whosoever is having or claiming to have a title, a right in the property which has been ordered to be attached, उसके rights वही हैं, they survive, right? So moratorium क्या बोलता है कि आपका right CD का रहेगा, सिक्योर क्रेडिटर का जहाँ राइट था वो नहीं रहेगा, पर कोई एक्शन नहीं लेगा. तो हम भी तो यही कर रहे हैं, मतलब ईडी भी तो यही चाह रहा है कि जब तक डिसाइड नहीं होता है. बट प्रॉब्लम इज विदाउट हैविंग द फाइनल ड्रास्टिक ओपिनियन इज टेकन एट द स्टार्ट ऑफ द प्रोसीडिंग्स इटसेल्फ कि एक्यूज्ड इज जो हमारा बेसिक रूल ऑफ लॉ है, जो नॉट लॉ, बेसिक रूल ऑफ जस्टिस है, फंडामेंटल रूल ऑफ जस्टिस. An accused is not an accused till such time he's proved guilty, he's innocent. But here you are accused till such you are guilty till such time you prove your innocence. So the burden of proof is lying on the people who are being accused till such time they are acquitted. As ये basic fundamental difference है from the other laws. Honorable SC also observed that the attachment under the PMLA is not an attachment for debt, but principally a measure to deprive an entity of property and assets which comprise of proceeds of crime, and they actually wish to punish that entity. Attachment under PMLA does not result in an extinguishment or effacement of property rights. It is an essentially It is essentially a fetter placed upon, a deterrent placed upon possessor of that property to deal with the same till such time the proceedings under the aforesaid enactment come to a definitive conclusion, or maybe question of confiscation is decided. Thus, since the act of attachment does not result in effacement of rights in the property, it would clearly stand and survive outside the scope of moratorium or an action in respect of a debt due or payable. It ruled that the moratorium under section 14 of IBC would not affect the attachment of tainted property. Moratorium under section 14 of IBC would not affect the attachment of property under 5 and 8, notwithstanding the pendency of CRP, as such attachment is not an action for enforcement of debt. Attachment under PMLA is not an attachment for debt, but primarily a measure to deprive the entity of the property and assets which comprise proceeds of crime. The Honorable SC further ruled that the principle that the latter act shall prevail is not an inviolable rule applicable in case of conflict between the two special statutes, both having non-obstante clauses. Therefore, by virtue of this principle, one cannot mechanically conclude that moratorium under IBC would gain an overriding effect over the attachment actions under PMLA without having regard to section 32A, which was enacted later to clarify the extent to which the provisions of PMLA are to give way to the proceedings initiated under IBC. The HC further stated that it is also necessary to understand that the position of the government under PMLA is not similar to a secured creditor, very important point, thereby equating the position and blatantly stating that the IBC shall override PMLA after the insertion of 32A shall severely affect the severely affect the legislative aim and policies of PMLA and the ultimate image of the nation and the recoveries and the punishment and all those macro level goals and aims of the UN imposed upon its members will come into play. Both the legislations shall be construed in harmonious manner to not frustrate the intent and objects of the legislations. However, the protection prescribed under the newly inserted provision is with regard to the new management of CD and the assets of CD only to the extent of compliance of 32A. Thereby, it is quintessential to strike a balance between the two different legislations. Otherwise, persons involved in proceeds of crime shall abuse the law relating to IBC to escape from the liability resultantly affecting the revenue. The current judgment given by the Honorable HC does not put an end to unending battle between IBC and PMLA, thus giving rise to a debate over the effect of insolvency proceedings on the powers of ED. As far as section 32A is concerned, the Honorable SC drew the line for ED and observed that it has the effect of ending PMLA proceedings only in two trigger cases: when the resolution plan is approved or when the assets of CD are sold to a person other than ex-management, so on and so forth. In furtherance, very recently, Honorable SC in the matter of Ashok Kumar Saraugi versus ED issued a notice which sought to challenge the decision of NCLAT in Varsana Ispat and Kiran Shah cases. We will discuss these cases later. Conclusively, it is yet to be deciphered as to how the Apex Court would bring the matter to rest and crystallize the abstruse legal position. In the matter of Solidaire India Limited, the Supreme Court held that where there are two special statutes which contain non-obstante clauses, the later statute must prevail. सुप्रीम कोर्ट मुझे लग रहा है खुद ही कंफ्यूज है, तो किसी मैटर में कुछ बोलते हैं, किसी में कुछ बोलते हैं. If the legislature does not want the later enactment to prevail, then it would expressly provide in the later enactment that the provisions of earlier enactment will continue to apply. It is to be noted that there is no such explicit provision for overriding the other laws as such specified in IBC. Therefore, keeping the same rule in mind, many judgments confirmed IBC overriding other statutes, including PMLA. However, this principle cannot be applied in all cases, and other aspects of the statute, including the objectives, become relevant factor in resolving a conflict in the provisions. Similarly, a conflict in the provisions of IBC and PMLA cannot be decided merely by looking at the year in which the statutes have been enacted. Nitin Jan liquidator versus PSL Limited, liquidator of PSL Limited versus ED. In regard to the interplay between, this is a judgment. I would request all of you to read, because and especially those who are dealing with any such subject of PMLA, to keep your thinking clear on how and why this battle is not being rested, why it is taking so much of time for government to draft policies, why it is taking so much of time for SC to decide the matter. This judgment is such a long judgment. It embodies almost all the relevant case matters related to the subject in itself, and I have also taken relevant portions from this judgment so that we understand the actual reasons behind this thinking. हमें बाहर से देख के मुझे खुद को बहुत funny लग रहा था. Every NCLAT is changing its view. After 1 year, the view is changed. Delhi High Court has changed its view from one matter to the other. But the thinking is also evolving with time, and people are at the center, especially the members. It is a tremendous responsibility to give the correct judgment. So every time they apply their mind, that there might be a change of understanding behind, and more research is carried on before the next judgment is pronounced, even if it belongs to the similar matter. So it says the interplay between the provisions of IBC and PMLA and whether primacy could be according to one of those enactments would directly fell for consideration before a learned judge of this court in ED versus Axis Bank. The court, Delhi High Court has given ED versus Axis Bank, Delhi High Court has given Nitin Chan, Delhi High Court has given Rajiv Chakrabarti. But you read all of them have different contentions. The court in that matter was dealing with appeals brought by the ED against the decision delivered by the appellate under the PMLA, which had held that the rights of banks and financial institutions as recognized in the SARFACI, RDP, or the IBC would rank superior, and that the PMLA would have to take a backseat. While a number of other important aspects pertaining to the provisions of PMLA have also been considered, we are, for the purposes of the present matter, concerned only insofar as the said decision deals with the questions posited in this respective matter. Dealing with the interplay, the learned judge held that from the above decision it is clear that the objects and reasons of enactment of the four legislations are distinct, each operating in different field. There is no overlap. While Recovery of Debts and Bankruptcy Act had been enacted to provide for speedier remedy for banks and financial institutions to recover their dues, SARFACI aims at facilitating the secured creditors to expeditiously and effectively enforce their security interest. In each case, the amount to be recovered is due to the claimant, that is the banks or the financial institutions or the secured creditor, as the case may be, the claim being against the debtor. And the Insolvency Code, in contrast, seeks to primarily protect the interest of creditors by entrusting them with the responsibility to seek resolution through a professional failure on his part, leading eventually to the liquidation. With the interplay of the statutes, the SC has further held that the respondent have referred to the following observations of Supreme Court in the order dated so and so. In the appeal, Principal Commissioner of Income Tax versus Monetary Ispat and Energy. Given Section 238 of IBC, it is obvious that the code will override anything inconsistent contained in any other enactment, including the Income Tax Act. We may also refer to this connection in Dena Bank versus Bighabai, Prabhudas Parekh and Company, and its progeny, making it clear that income tax dues, being in the nature of crown debts, do not take precedence even over secured creditors who are private persons, right? So government debts, priority of payment of government debts has been put on a lower pedestal under IBC, and that fact has been kept in mind while while these judgments were being given. Noticeably, the effect of Insolvency Code on PMLA was not in issue before the Supreme Court in the aforesaid case. The prime concern being the conflict arising out of claims of income tax vis-a-vis proceedings under IBC. For the same reasons, the ruling of the full bench of Madras High Court in Indian Overseas Bank would also have no effect here. A resolution professional appointed under the Insolvency Code does not have a personal stake. He only represents the interest of creditors. Their committee having appointed and tasked him with certain responsibility under the said law, the moratorium enforced in terms of Section 14 of IBC cannot come in way of the statutory authority conferred by PMLA on the enforcement officers for depriving a person of the proceeds of crime. A view to the contrary, if taken, would defeat the objective of PMLA by opening an escape route. After all, a person indulged in money laundering cannot be permitted to avail of the proceeds of crime to get a discharge of his civil liability towards the creditor for the simple reason that such assets are not lawfully his to claim. To sum up on the issue, the objective of the legislation in PMLA being distinct from the purposes of the three other enactments, that is RDBA, SARFAC and IBC, the latter cannot prevail over the former. There is no inconsistency in this case. The purpose, the text and the context are different. This court thus rejects the argument of prevalence of the said laws over PMLA. I hope you are listening and it is getting registered in your mind, because this is very important to understand the perspective of the High Court. Dealing with the rights of creditors or persons in whose favor interest in property may have been created bona fide, the learned judge proceeded to hold that, in view of conclusion reached as above, rejecting the argument of prevalence of such acts, the said laws must coexist, each to be construed and enforced in harmony without one being in derogation to the other. With regard to the assets respecting which there is material available to show the same to have been derived or obtained as a result of criminal activity relating to a scheduled offence, rendering the same as a proceed of crime within the mischief of PMLA. The PMLA declares by virtue of Section 71 that it has overriding effect over other existing laws. Such provision containing non-obstantive clause with regard to consistency apparently to be construed as referable to the dealings in money laundering and proceeds of crime relating thereto. An order of attachment under PMLA, if it meets with the statutory prerequisites, is as lawful an action initiated by a bank or a financial institution or a secured creditor for recovery of dues legitimately claimed or for enforcement of secured interest in accordance with RDBA or SARFAC Act. The order of attachment under PMLA is not rendered illegal only because a secured creditor has a prior secured charge in the subject property. Conversely, mere issuance of an order of attachment cannot by itself render illegal the prior charge. As we have seen, those charges survive till the confiscation. In these conflicting claims, a balance has to be struck on account of exercise of the prerogative of the state under PMLA, the lawful interest of a third party which may have acted bona fide and with due diligence cannot be put in jeopardy. The claim of bona fide third party claimant cannot be sacrificed or defeated. A contrary view would be unfair, unjust, and consequently not the intention of legislature. The legislature scheme itself justifies this view. To illustrate, reference may be made to subsection 8 of section 8, where under a power, a power is conferred on the special court to direct the central government to restore a property to the claimant having a legitimate interest even after the order of confiscation has been passed. The law conceives of possibility of third-party interest in the property of a person accused of money laundering being created legitimately or conversely with ulterior motive to frustrate or to defeat the objective of law against money laundering. In case of tainted asset, that is to say a property acquired or obtained as a result of criminal activity, the interest acquired by a third party from person accused of money laundering, even if bona fide, for lawful adequate consideration, cannot result in the same being released from attachment or escape the confiscation since the law intends it to vest absolutely in the central government free from all encumbrances. The rights of such third party being restricted to sue the wrongdoer for the damages. The encumbrance, if created with the objective of defeating the law, is treated as void. In case an otherwise untainted asset is targeted by the ED for attachment under the second or third part of the definition of proceeds of crime, because they are also allowed. You remember, if the property is out of the reach, maybe out of the country, then a property having value equivalent to the property created out of the proceeds of crime can also be attached by the ED. For the reason that such asset is equivalent in value to the tainted asset that was derived or obtained by criminal activity, but which cannot be traced, the third party having a legitimate interest may approach the AA to seek its release by showing that the interest in such party was acquired bona fide for lawful consideration, there being no intent while acquiring such interest or charge to defeat or frustrate the law, neither the said property nor the said person claiming such interest having any connection with or being privy to the offense of money laundering. So that person can approach the AA to seek the release, and that provision is there in the law. Having regard to the above scheme of the law in PMLA, it is clear that if a bona fide third party claimant had acquired interest in the property which is being subjected to attachment at a time anterior to the commission of criminal activity, the product whereof is suspected as proceed of crime, the acquisition of such interest in the property by such third party cannot be on account of intent to defeat the law, because crime may have been crime may have occurred after the such purchase. In this view, it can be concluded that the date or the period of commission of criminal activity, which is the basis of such action under PMLA, can be safely treated as the cutoff. From this, it naturally follows that an interest in the property of an accused vesting in a third party acting bona fide for lawful and adequate consideration acquired prior to the commission of the prescribed offense, bringing illicit pecuniary benefit to the former, cannot be defeated or frustrated by attachment of such property to the extent by the ED in exercise of its powers. It further held it will be advantageous to summarize. Okay, now this is the summary of the entire discussion that has held, not the discussion, the judgment. And this is such a detailed judgment that one is this summary that they have given here, and they are so clear in what they are presenting, what they are delivering, that they have summarized it here in these points. They are almost.
It is taken from Nitin Jain case?
Yes.
This summarization?
Yes.
Okay.
It is in such a detail that if you wish to understand the PMLA, you read this judgment and you will be knowing better than the EDs also. It is a very good judgment, and it has also taken care of PMLA versus IBC at appropriate places. So I'm not going through the entire judgment now, because this would just be a repetition. Now, in the Manish Kumar versus Union of India matter, the Honorable Supreme Court of 32A, right? We are aware. So, Honorable HC held that must be remembered that the immunity under 32A, there must be a resolution plan, it must be approved. The disguised avatar of old management, it cannot even be the related party of the CD. The new management cannot be subject matter of an investigation which has resulted in material showing abatement or conspiracy of the commission of offense, and the report or complaint upon for claiming exemption of the bar from actions against the property. Significantly, every person who has associated with the CD in any manner and who was directly or indirectly involved in the commission of offense in the terms of reports submitted continues to be liable to be prosecuted and punished for the offense committed by the CD. So
Madam,
this is
will there be any difference or it is going to affect? Suppose the dissolution plan has been given to XYL promoter under exemption category, MSME?
no, then 32A immunity will not be available to them. It is very clearly written over there.
So even though you are eligible, but if you fall in any of the categories, just to, by way of like, you camouflage to gain the control over the
Yes,
company, you are not allowed.
then you will have to face the actions being taken against you under various laws. And if you are acquitted there, then the property is yours. One has to face those actions in that case. They do not get the clean slate because the slate is their own
Because
slate.
you are giving 29A declaration also, like while participating. Okay.
In MSME case, 29A shall.
Yes.
I said in the MSME case, 29A will not be applicable, no?
But in that case, that will be an
Also
unrelated
not be
entity, na?
applicable. Sorry?
But in that case, it should be an unrelated entity. Am I right?
No, unrelated entity cannot be, because see, the promoter itself is participating. So anyway, like, he's a related party.
What we are saying
But in this case, promoter cannot participate, na? If the AD is there.
Yeah, madam, what is your view?
yes, 29A में debar हो जाएगा ना promoter in that case.
Get disqualified, and
Yes.
They are disqualified.
what is coming out of all these judgments is that there is really no conflict, because under PMLA the idea is to take away the asset acquired from wrongful or rather proceeds of crime. And even under IBC, it does not stay unless the promoter is the applicant, which we know would not be a possibility. So therefore, both are actually in sync.
Yes.
Okay, now can we talk about in the circumstances as the IRP is appointed for a company whose assets are attached by the ED.
Okay.
Then what will be the functions of IRP? Can he go for keep to keep it as a going concern? See, take it as this is a real estate project.
Okay.
Can IRP go for constructing the flats as it is permitted in IBC to maximize the value of assets?
I think he cannot now seeing the
Ma'am, your voice is breaking.
being laid out of so many judgments around. Vacation. I think there is an internet issue.
Yes. Your
I
voice is not
continue
clear.
like this. IRP cannot go to the NCLT or any appropriate authority for vacating that attachment, right? Till such time those proceedings are going on.
Yes.
Right. So I think he may continue the construction with the approval of the ED, because it is not that any action is debarred. It is only that the action can be taken only in their knowledge and with their approval. And if it is for the bona fide of the, it is a bona fide action of the IRP to maintain the company as a going concern or to continue the construction in line with the objectives of IBC and CIRP has to be run and all that stuff. Even ED will have to grant permission. Maybe they will have some conditions imposed on him that he will not, and if the land is attached or that too one cannot take away, na? So land is secured in any case, and the other properties, if they are, I think a clarity needs to be brought on.
In that case, see, as the process is started by the order of NCLT. So now should I approach to NCLT to get directions to ED?
First, you will need to go to ED. Obviously, will not respond favorably in the first on the request itself, then you go to NCLT. That is the route available to us.
But here the point is, ma'am, when we are talking about कि both the acts are, prevailing each other, or जो भी हमने discuss किया अभी, so whether the directions of NCLT, say I get the directions from the NCLT to ED, will that be recognized by the ED?
Once they are not recognizing that, then you go to High Court.
But can NCLT give direction to ED is also something that we need
that is
to.
also a question.
I don't think NCLT would have the jurisdiction to give a direction to ED.
See, we have a dilemma. If we go to ED, they'll not entertain us. If we go to NCLT, they are not able to give the directions. Then what RP will do?
I think the High Court can give the best solution to this.
Ma'am, you said that you have handled, your experience. Could you just share, how you, managed to get through, these kind of cases, and you have come to a resolution plan for that company?
Actually, I have not experienced the any.
Sir, plan तो, ma'am, I'm sorry. Sir, plan तो आ जाएगा. Plan में कोई problem नहीं है. Because 32A जो है बाद में आ जाएगा सामने picture में, तो then there'll not be any problem. But the point is कि when we have the time in the CRP, what RP कितना कर सकता है उसमें?
Sir, RP at the most कर सकता है, NCLT में जाके application लगा ही सकता है कि the case, because see, अगर हम ED के पास जाएंगे, NCLT के पास नहीं जाएंगे, so NCLT will take it differently.
Because you have to finish all your remedies in hand, na? Then only you can approach to the higher authority.
And before initiating any suit, you anyway have to take clearance.
Permission.
Yes. So, and as far as the resolution process itself is concerned, I think with proper disclosures in the IM, it's perfectly fine to proceed with the CIRP. Yeah, the question then remains is whether, as for keeping it as a going concern, you can take any action or not. But CIRP should not be a challenge, in my opinion.
But construction could be. For that matter, you might need to take specific approvals from the ED office or something. And if they are, they have also grown up with the act by now.
Okay. See, when all the learned members are here, now suggest me where should I go first, NCLT or ED?
ED, of course. Once they decline your request, and
what other members say?
You will have to approach NCLT before you initiate any suit. This is more by way of intimation that this is the scenario or this is where you are stuck, and make an application that is more in a kind of a formality that you have to fulfill, and then move the PMLA code. That's my opinion. I don't know.
Yeah, I've also acted in the same manner in one of my case. First of all, I moved an application before the Honorable NCLT. Then I represented my corporate debtor to the special court in Delhi.
What was the view of NCLT, sir?
NCLT, the matter was still, sub judice. Nothing could be
See, this is a major problem.
Yes.
Nowadays, nothing is happening in NCLT.
yes.
And even then, if it happens, suppose if there is any order, again it is going to be challenged regarding the preference overriding effect.
Anyway, yes.
And I doubt that NCLT can give any kind of direction, so they will desist from giving any clear-cut order in any.
I tell you one thing. In one of my case, we were seeking direction against the Electricity Board of the state, and NCLT said this is not in our prerogative. So what about ED? When they're not able to give direction to
that's not my experience, because I had a similar problem. So the order that came out of NCLT was very clear that their past dues need not be paid. However, whatever was to be incurred during CIRP had to be cleared.
Yeah, that is fine, ma'am. That is clear. Actually, we were going there. We were with the NCLT because of the reason कि इलेक्ट्रिसिटी हमारे प्रोजेक्ट पे नहीं थी, तो वी वर देयर टू सीक द डायरेक्शन टू इलेक्ट्रिसिटी बोर्ड टू इंस्टॉल to go for this substation, and they say this is not in our range.
Yes. तो वहां पे आपका नया कनेक्शन था. In my case, it was an existing connection. There was demand for electricity bill.
My point is when the CRP started with the order of the NCLT, where I'll go for the relief.
First to, of course, to NCLT only. And
definitely.
In some cases, NCLT has passed orders for release of attachment and then has gone to NCLT. And now everything is jumbled up at Supreme Court. In Rajkumar ji was asking my experience. I am in the knowledge of some matters where my partners are involved as RP. I have not directly handled any such case where PMLA has been involved. But they are only waiting for that. In some matters, there has been a stay. And in some matters, they are just waiting for the final verdict of Supreme Court.
So, madam, what is the fate of those assets?
Those assets will be under the possession of ED only. Not the possession, I must say, under the provisional or the confirmed attachment, whatever the stage they are lying at.
So, for that sake, like, my resolution plan and the liquidation process shouldn't get stalled.
It gets stalled. Yeah, you are right. You are right. Harmeet ma'am must be telling the same thing. In my case, the liquidation started on February 2018, and still the matter is being dragged because one of the part of the property is attached by ED, and just I am fighting at various forums, various courts to get any order, favorable order. But since there is no such order, the matter is being pending. So it started in February 2018, already 5 years gone.
So, Sikdar sir, you had taken extension for your liquidation process?
Yes. Every time I'm getting extension. Yes,
based on that.
Yes, without that I cannot keep it pending now.
Yes.
So that's my
Sir, you are talking of attachment in my matter where I'm liquidator. The promoter's related party is claiming possession, and the NCLT is asking whether they are competent. This is liquidation, mind you. The NCLT is considering whether they are competent to order eviction. So, I mean, attachment by PMLA is a far graver situation.
No, but actually I don't know, I could not get it. But supposingly, if it is the property or the asset belongs to the CD, and if you are the liquidator, definitely it is your right to get it.
Absolutely, under Section 36. But see, what has happened is that the related party has gone and approached NCLT. Now they seized of the matter and they're wondering, it's still being heard, whether they are competent to order eviction or should a civil suit be instituted. I don't understand, because we are under moratorium, no fresh suit can be started, and when you are in liquidation anyway, the only conclusion is that the company has to, you just need to pull the plug. So ED and all is a far serious matter, I would say.
Yeah, definitely understand. But in your case, I think it's a very clear-cut case, and NCLT should give the order in your favor.
Absolutely.
And definitely, I don't think there should be any problem for honorable NCLT to give any direction.
And that too, in this matter, what has happened is that they're showing a development agreement by which they're claiming possession. Now, the best case scenario for them is to, have set their claim before me, right? But instead of doing that, they are claiming possession and things like that, unnecessarily delaying the whole process.
Let's go back to where we were. All right. So about Section 32A also, the Honorable High Court has has stated something in the same Nitin Jain order. A close reading of Section 32A 1 and 2 establishes that the legislature in its wisdom has erected two unfaltering barriers. It firstly prescribes that the offense, which may entail either prosecution of the debtor or proceedings against his properties, must be done which was committed prior to the commencement of CRP. Secondly, the cessation of liability for the offences committed is to occur the moment when a resolution is approved by the AA or upon the sale of liquidation assets. The provision in unequivocal terms terminates the prospect of prosecution or coercive action against properties on the happening of either of these two critical events. So, Supreme Court in Manish Kumar matter also said, in the same judgment this has been referred, reliance is placed on the report of Insolvency Law Committee. The relevant extract is as follows. The committee agreed that the property of a CD, when taken over by an RA or when sold to a bona fide bidder in the liquidation, should be protected from such enforcement action, and the new section discussed in para so and so, that is 32A, should provide for the same. Here too, the committee agreed that the protection given to the CD's assets should in no way prevent the relevant investigating authorities from taking action against the property of persons in the erstwhile management of the CD that may have been involved in the commission of such criminal offense. So it is necessary to understand the position of government under PMLA is not similar to that of a secured creditor, thereby equating the position and blatantly stating that IBC should override PMLA after the insertion of 32A shall severely affect the legislative aim and policies. Now they have given a summary in a summation form. This is also very interesting part of this judgment. So this is going through A, B, C up to point, T. So this is the whole summary of whatever they have derived through all the discussion and all the references made in the High Court judgment. So I would not go through all of them, though I have placed them for reading, but I don't think reading the same things again would make it much of a difference, because by now we understand the logic behind why these two contexts are different, and we have understood the thinking behind making such verdicts. So let's move on to the other matters. In Varsana Ispat Limited and the ED, the Honorable NCLAT has held that PMLA deals with the proceeds of crime, and it was also held that the Section 14 is not applicable to such proceeding. Further, while analyzing the scope of Section 14 of IBC, it was held that it will be applicable to the individual, which may include ex-directors and shareholders of the CD, and they cannot be given protection from the PMLA. And such individual cannot take advantage of the Section 14. The attachments were made prior to the initiation of CIRP, therefore no advantage of CIRP should be derived. It also observed that PMLA relates to the proceeds of crime and the offense relates to money laundering, resulting in confiscation of property derived from or involved in the money laundering. Thus, Section 14 is not applicable to such proceeding. Actually, CD is not the legitimate owner of that property. Further, the NCLAT also observed that so far as penalty is concerned, offense of money laundering is punishable with rigorous imprisonment, which is applicable to an individual, which may include the former directors and shareholders of the CD who cannot take any advantage under Section 14. In the matter of Kiran Shah, RP of KSL and Industries versus ED, NCLAT held that the Honorable SC had confirmed this judgment of Varsana through an order dated so-and-so in civil appeal, and the same has become final, conclusive, and is of binding value. In the Andhra Bank versus Sterling Biotech Limited, it was held that insofar as the assets of CD are concerned, if it is based on the proceeds of crime, it is always open to the ED to seize the assets of the CD and act in accordance with PMLA. However, it will not come in the way of the individual such as promoter or shareholder or director if he pays not from the proceeds of crime but in his individual capacity the amount from his account and not from the account or assets of the CD and satisfies all the stakeholders including the financial creditors and OCs. There is nothing on the record to suggest that individual property of promoter or shareholder or director who proposed to pay the amount has been subjected to restraint by the ED. Therefore, even if the asset of the CD is held to be proceeds of crime, the AA cannot reject the prayer for withdrawal of application under Section 7 if the promoter in their individual capacity satisfy the creditors. Sterling Biotech was I actually cannot read the headings.
Sterling Biotech was reinforced in Rotomac
Global
yes.
versus Deputy Director of ED. In Rotomac Global Private Limited versus ED, the NCLT held that the proceedings under PMLA are penal in nature and the Section 14 of IBC is not applicable on them. Since the objectives of both the enactments are different, proceedings can be invoked simultaneously and none of them will have an overriding effect on each other. In the Manoj Kumar matter, the NCLAT affirmed the order passed by NCLT Mumbai and observed that there is no conflict between PMLA and IBC, and even if a property has been attached in the PMLA which is belonging to the CD, if the CIP is initiated, the property should become available to fulfill the objects of IBC till a resolution takes place or a sale or liquidation of assets occurs in terms of 32A. So this is a conflicting view. The NCLT had held that the attachment order passed by ED was nullity and non-est in law in terms of Section C. Shyamji, you can just refer this judgment and take this NCLAT judgment, which has been, negated by the further judgments of even NCLAT and High Court. But this might come in rescue. You can at least start an NCLT case with this.
Right. Yeah.
Had also permitted the resolution professional to take charge and deal with the properties of the CD as if there is no attachment order. Chandraprakash Jain versus Mayfair Label. So this application is filed by the applicant under section so and so, seeking release of attachment of property by the ED. AA held that the Honorable High Court of Madras in matter of ED, Joint Director of ED versus Asset Reconstruction Company of India Limited and others observed that NCLT has no jurisdiction to go to the matters governed under PMLA, and therefore Section 14 having consequent upon an order passed by AA declaring moratorium would not apply to PMLA, which is distinct and special statute having its own objective, and as such Section 14 would not bar a proceeding under this act. It is clear that the proper recourse to be resorted by the CD is to approach the competent forum under PMLA to its logical end or any other jurisdictional forum other than the purview of IBC in the manner known to the law and in accordance with law. In view thereof, the application stood rejected. Kiran Shah RP of KSL and Industries versus ED. Larger bench of NCLAT in the case of Kiran Shah held that Section 14 of IBC does not come in the way of ED's officials exercising their powers under PMLA, which paves a way for a decision diametrically opposite to the one held in Manoj Kumar Agarwal case, which we just saw. It has held that in so far as the decision in Manoj Kumar Agarwal case is concerned, this tribunal is of the considered opinion that the said decision runs contra to the principle of stare decisis. NCLAT held that in fact the PMLA is to fulfill our country's obligation in adhering to the UN resolutions, and in regard to assets or properties being the proceeds of crime, it takes a primacy and precedence over the IBC, which promotes resolution as its objective over liquidation in the considered opinion of this tribunal. ऐसे देखने में IBC कितना छोटा सा लगता है ना, PMLA कितना ऐसे present करते हैं जब. Besides this, the objective and purpose of two enactments, even though at the first blush appear to be at loggerheads, there is no repugnancy and inconsistency between them in lieu of the fact the text, shape and color are conspicuously distinct and different, operating in their respective spheres. More importantly, when confiscation of proceeds of crime takes place, the said act is performed by the government, not in its status or capacity or role as a creditor. Messrs. Packwell India Limited versus Messrs. MG Cables and Communications Limited, the liquidator filed an application before AA seeking directions to carry out the auction of properties of the CD which were attached. the AA directed to lift the order of attachment of the properties of CD under the PMLA. It observed that the IBC creates a specific bar with respect to proceedings that may be initiated under PMLA by virtue of provisions contained in section 32A. Moreover, 32A cannot possibly be read as being applicable prior to a resolution plan being approved or a liquidation measure being enforced. Further, it can therefore be construed that the objective and intention of code is providing a free hand to the creditors. As if the properties of CD are attached, then it will jeopardize the liquidation process. That means you cannot just sell, and the intent of 32A is to provide a clean title to the buyer. So if you cannot sell only, then how will you implement 32A? Mr. Central Papers and I cannot read that, versus Deputy Commissioner of Income Tax. It was pointed out this case law is not related to the PMLA Act, but I have taken out certain points which are harping upon the meaning of the terms. It is pointed out that there should be a clear inconsistency between the two acts before giving an overriding effect to the non-obstante clause as per decision in so and so act. So this central paper was matter was in case of Commissioner of Income Tax and some Binani Property Act. If one finds two or more enactments operating in the same field and each containing a non-obstante clause stating that its provisions will have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, then one is to see the purpose and policy underlying the two enactments and the language used in them. Ordinarily, there is a close proximity between the non-obstante clause and enacting part of the section. A non-obstante clause may throw some light as to the scope and ambit of enacting part in case of its ambiguity. So,
Here mean policy, here mean the public policy.
which policy, sorry?
Could you just come to your last line? Purpose and policy in 58, the second
Policy here means the law.
law.
Other than this section, what is the intent of the law otherwise? In which direction is the law talking about? Like our law was talking about resolution and giving a clean title to the buyer. In that case, the intent of the law has to be seen in 238 has to be seen in perspective of 32A also.
Or does this policy has got to do with some public policy wherein sometimes decisions are taken, I mean, keeping in view of the effect of that any activity, whether it is going to affect the public at large?
I don't think you read this para 58 of this judgment. I don't think this policy is used to connote all the laws embodied along with that particular act that we are talking about. The regulations, the preamble, everything has to be read. So we are fully confused and we are just waiting for this SLP, as well as there are numerous SLPs. In solely this case with SC, there are 15 matters which are tagged, and I could see 2-3 more matters where again numerous matters are tagged. So we are all we are all waiting for this Supreme Court verdict, and Supreme Court is actually, I think, delaying the final verdict only because it has asked central government to draft some policy, not the policy, draft some rules in this regard so that a clarity can prevail.
If any idea when this matter is listed at Supreme Court, the last one?
Actually this was not updated over there.
Because it was sometimes I read somewhere it was in the month of August 22.
It was there expected in November 22.
November 22, okay.
Still the reply has rejoined us. वो सब अभी motion चल रहा होगा. Therefore, the dates of the next hearing are not yet published anywhere. So the conflict arising due to applicability of the IBC with PMLA in some situations has led to perplexity in the outcome of CIRP or liquidation, and there has been immense turmoil due to various judgments. Nothing is reliably established till now. Furthermore, an appeal filed in the matter of Ashok Kumar Saraugi versus ED has stimulated the Honorable Supreme Court to take a decision on the overriding effect. Not only Ashok Kumar, there are many other matters now. The Apex Court will also provide its views on whether the moratorium also applies to actions initiated by ED. It is hoped that the order that will be passed by the Apex Court in the pending matters would clarify many questions in relation to interplay between the two statutes, including as to whether assets attached under PMLA either prior to or during the CRP would be considered in the pool of CDS assets, whether ED would be considered as a creditor, if yes, then in what capacity, action under PMLA being criminal in nature, whether the same can be allowed to continue against the assets standing in the name of CD, etc. Given the objects of both statutes, the Apex Court may strike a balance of ensuring successful revival of stress.
And this is another problem. The point number 2, whether ED should be considered as a creditor.
Yeah.
Will create more mess.
Every day another Vidarbha case.
Yes.
हाँ.
सर ये तो किसी को कुछ पहले नहीं करने दे रहे हैं, बाद में तो वैसे भी नहीं करने देंगे.
नहीं, clarity will surely come on this. They cannot be treated as creditor क्योंकि banks.
I think this point will not be there. Whether it should be considered as a creditor.
Because बहुत सारे judgment में आपने जो दिखाया उसमें they are not considered as a creditor.
Yes.
This is totally a separate concept.
So the court may strike a balance of ensuring successful revival of stressed entities without allowing offenders to go scot-free with laundered money. So what we derive from today's discussion is that there is no blanket rule and some factors should be considered, like approval of CRP under IBC, the origin of scheduled offense, generation of proceeds of money, committing offense of money laundering, whether the offense was which was the cutoff date, etc., interlinkages between the assets confiscated and the proceeds of crime, involvement of new management, if any, in the offense under PMLA. And the objectives of both the laws are significant for the economy. IBC encourages the revival of stressed companies, safeguards the interests of majorly the banks. PMLA strives against the money laundering offense to prohibit criminals from enjoying proceeds of crime and who can deter the economic growth. Hence, the utmost priority is to strike a balanced approach under IBC along with catching hold of offenders of money laundering. To remove the ambiguity of overriding effect of either MLA or IBC, everyone is eyeing the Supreme Court order. So are we. So what should be the role of courts in this to balance out the objectives? The investigating authorities like ED and SEBI might be considered as OCs, might be under the ambit on dues against government authorities. This will provide a common ground wherein the conflicting interests of both the government agencies will be settled. Thus, a rule of interpretation. As a rule, the courts should apply harmonious construction between the two conflicting laws and should ensure the objectives and purposes of both statutes are met. At the same time, government should take steps to deal with ambiguities and clear their position concerning them. International cooperation agreement, we have already spoken about it. I'm not. So the conclusion on time. So the conclusion of today's discussion is the power of PMLA to attach assets is affected as and when 32A comes up. While the IBC can play its part in timely resolution and realization, the ecosystem will have to look beyond IBC framework in silos and strive to connect the dots towards the next. It is a concerted effort by multiple policy initiatives, well sharpened by regulated forbearance and fortitude and action at the ecosystem level that ensures the economy taking meaningful strides in the pursuit of the next. I think this is it. And if we have any questions, can discuss. Thank you.
Ma'am, we have a request. Kindly share your PPT with us.
Sure, I will. I have
Sir, I'll share it. Sir, ma'am will share it with us and we'll share it with all the participants.
Yeah, thank you so much.
But it should come.
Yeah, it should come.
It does come. I do receive. I receive presentations of many speakers.
Yes.
This is very relevant.
Yeah, and very summarized. I mean,
yes,
chronological
It will be of a good help.
Substance, yes.
Thank you.
Very detailed. I mean, it has covered a
Yes.
whole lot of.
Yeah.
Thank you, Harmeet ma'am.
Thank you so much. And
Thank
we don't
you.
switch on the cameras. Can I take a screenshot?
Yes, ma'am. Yes, ma'am. Sure.
Yeah, please switch on the camera and I am requesting. Although we don't get 47 participants on the same screen, but whosoever is there. Thank you.
Thank you very
Thank you
much.
so much, ma'am,
Thank you.
for
Thank you, ma'am.
Thank
for
you.
taking out the time and making such a detailed, comprehensive presentation and engaging so many participants in the presentation as well.
That's the key.
Yes, ma'am, it was a very, very interactive session. And I'm sure everybody who attended, who listened, gained a lot from it because everybody shared their opinions and everybody shared their issues and thoughts and everything. So thank you so much, ma'am, for agreeing to take this session and for taking the time out and for engaging so many participants. It was
Thank
very
you, everyone.
insightful.
Thank you, Ankita. Thank you to the institute.
Thank you so much, ma'am.
I must compliment Mr. Arnav Sikdar. He has also contributed in my understanding of the subject, and we keep writing on it. My camera was not working. Thank you, Rajiv ji. Thank you, everyone.
Thank you, ma'am. Thank you very much.
Thank you so
All
much,
right.
ma'am.
Thank you.
Thank you.
Thank you.
Thank you to all the participants as well. We'll share the PPTs and
Yes.
the CPE mailer.
Yeah,
मैडम
thank
के
you.
पीछे पड़ जाइए PPT.
No, ma'am shares the PPT quite quickly, and as soon as I receive it, I'll share it with everybody.
Okay, fine.
Okay, ji.
Thank you.
Thank you.
Okay, thank you.
Thank you.
Thank you.